The Rules Committee will come to order. We are here for consideration of resolution from the Oversight and Government Reform Committee. Before we begin, let me officially welcome back to the dais the distinguished ranking member of the Rules Committee, Mrs. Slaughter, and she's been making appearances here in the Rules Committee, but she comes in with this very dramatic opening of the doors in her spectacular go-kart, is what I've called it. And she comes rolling in, and, there are pedals thrown behind and all, and so now I turn, and she's just sitting here. But she's also here with the wonderful Bob Slaughter, and we're always pleased to welcome him back to the Rules Committee. Sitting next to Mr. Slaughter, I know we've got a team of Pete Sessions interns who are here, and I have a couple of special guests I would like to introduce who are good friends of mine. Thank you, gentlemen, for forbearing and letting me introduce some of the very important people here. Yes, thanks for reminding me of that. It's not mine, it's the Rules Committee. I'm very happy to welcome the distinguished ambassador from Pakistan, my good friend Sherry Raymond, who is here, and we've just been meeting talking about the great challenges that exist, and we're continuing to work diligently to seek a resolution. Pakistan is a very important country and a good friend, and we need to work through these. And so, Madam Ambassador, it's always wonderful to be with you, and thank you for being here. And while it's always fun to be with Sherry Raymond, it's most fun to be with my guest who's back in the corner there. For any of you who may have at midnight on New Year's Eve turned on television and watched Dick Clark's Rockin' New Year's Eve, you've seen this woman kiss Dick Clark. Well, that is his wonderful widow now, very sadly, Carrie Clark, who has joined us, who is here. And I've talked often about this painting, and that is a property that was Carrie and Dick's that is there looking out at the Pacific Ocean, and it's because of the Pacific Ocean, Malibu, that I've become such great friends of Carrie's and Dick's over the years. And so, Carrie, we are, again, very saddened by your loss, and it's a loss for you, and it's a loss for those of us who knew your wonderful, wonderful husband, and for people in the world who obviously knew of Dick Clark and the great contribution that he made. And I want to say something about him that was not said at the memorial service, and that was Dick Clark was the epitome of the American spirit, and he is someone who loved the United States of America. And so it's great for us to be able to welcome you here, Carrie. Let me welcome our two witnesses, the chair and ranking minority member of the Committee on Oversight and Government Reform, and to say, gentlemen, any prepared statement that you have will appear in the record in its entirety, and we welcome your summary. So please proceed, Mr. Issa.
Thank you, Mr. Chairman. The rule you're now considering centers around actions that came to our attention as a result of the December 14, 2010 murder of Border Patrol Brian Terry in a canyon west of Rio Rico, Arizona. That led to a whistleblower letting the ranking member on Judiciary in the Senate, Chuck Grassley, Senator Grassley, know that in fact the weapons found at the scene, two of them, of his murder came from an operation known as Fast and Furious. Senator Grassley sent a letter to the then Attorney General Holder, who essentially responded through his Deputy Attorney General that there would be no action, no response forthcoming because he wasn't a chairman. Senator Grassley came to our committee and asked if we would help. I put a chairman's stamp on the request, and we began working to try to get to the bottom of the killing of Brian Terry and this operation that we knew little about called Fast and Furious. Over the last year and a half, the committee has found the Department of Justice to be uncooperative at every step of the way. First and foremost, on February 4th, a letter which was patently false was delivered to Senator Grassley with a copy to myself. Testimony from the Department of Justice shortly afterwards, compounded by reiterating what ultimately was and now is undeniably, admittedly, false statements made by Justice in which they asserted that they never let guns walk. The truth is, Fast and Furious was a program all about walking guns with little or no control over where they went until they showed up at the scene of the deaths both north and south of the border, particularly south of the border where, according to the LA Times, at least 150 Mexicans have been killed and estimates run to well over 300. The fact is 2,000 weapons were let walk in Fast and Furious. Many pieces of misinformation have been put out by the Department of Justice, but we're not seeking contempt over their misinformation. As a result of the February 4th letter, 10 months passed before the Department of Justice admitted that, in fact, in layman's terms, they had lied. When that was taken back, we asked, in addition to our other investigations, for the information around how that February 4th letter came to be given to us with false information on it. In other words, who produced these false statements, since many of the people involved clearly knew better. And during the intervening 10 months, when did they know we'd been lied to, and why weren't we told anything about it sooner? It's that February 4th to December of 2011 period in which we seek contempt, because the Attorney General, even before the President's assertion of executive privilege, said he would not give us any materials related and cited that these were internal, deliberative process, and as such, he had no intention of turning them over. Case law is clear, Mr. Chairman, Ranking Member, that, in fact, neither executive privilege of the President nor of any agency can overcome a legitimate need by Congress or an investigation of criminal wrongdoing. In other words, since Nixon, we've understood that executive privilege does not trump the actual question of, was Congress lied to, or were they covering up a crime? So you understand, even as we speak today, we still hold out a hand to the Attorney General. Even tomorrow morning, if in fact there is a substantial discovery change and we're able to get meaningful information, then we will in fact change our position on contempt. But until that occurs, we have no choice but to ask you to go forward with the rule and forward with the bill tomorrow.
Thank you very much, Mr. Rice. I appreciate it. Mr. Cummings, it's nice to see you. Welcome back to the Rules Committee.
It's good to be with you.
As I said, any prepared remarks that you have will appear in the record, and we'd welcome your summary.
Mr. Chairman and Madam Ranking Member, members of the committee, I want to thank you for allowing me to be here today. As you consider this rule, I urge you to take a step back and seriously consider what we're doing. Why are we rushing to the House floor with an unprecedented contempt vote against the Attorney General of the United States, our nation's chief law enforcement officer, a mere 7 days after it was voted on by the committee? This is one of the most serious actions that we will take as a Congress, so serious that it would be the first time in history that the House of Representatives have ever held a sitting Attorney General in contempt. Yet, this very meeting of the Rules Committee was noticed as an emergency meeting. Why is that? Why are we steamrolling ahead on a matter of such gravity? In my opinion, the answer is plain and simple: politics. When we first heard about these allegations of gun walking at ATF, I was outraged, and I supported the committee's goals of finding out how gun walking originated, how it was utilized, and how it may have contributed to the death of a Border Patrol agent, Brian Terry. But the committee's contempt vote last week was a culmination of one of the most highly politicized congressional investigations in decades. During the committee's year-and-a-half investigation, the chairman refused every single Democratic request for witnesses. Can you believe that? I know a lot of you are on other committees, and you have been in both the majority and minority, but have you ever heard of a 16-month investigation in which no minority witnesses were allowed? I have never experienced that since I've been here in Congress in 16 years. And this was not just a procedural issue. We asked the chairman at least 10 times in letters, at hearings, at business meetings to invite the head of ATF to testify, Ken Melson. We also asked to hear from the deputy of ATF, William Hoover. These were the leaders of ATF, the agency that ran these gun walking operations, but our committee members never had a chance to ask them a single question. How can you have an investigation of gun walking at the ATF and never hold a single hearing with the ATF leadership? In my opinion, this was one of the most significant flaws of our investigation, and I think that it undermines our efforts. How can anyone view our committee's work as legitimate or credible? In this case, the chairman refused our request for a public hearing after Mr. Melson met privately with committee investigators in July of 2011. During that interview, he stated that he never, that is, Mr. Melson, stated he never informed senior officials at the Justice Department about gun walking because he was unaware of it himself. This was significant because it directly contradicted the chairman's repeated allegations that the Attorney General authorized gun walking. Another serious failure of our investigation has been the chairman's refusal on multiple requests for former Attorney General Michael Mukasey to testify before the committee, or even to meet the committee informally to discuss the origination and evolution of gun walking operations since their start in 2006. Documents obtained during the investigation indicate that Mr. Mukasey was briefed personally on botched efforts to coordinate firearms interdictions with Mexican law enforcement officials in 2007 and was informed directly that such efforts would be expanded during his tenure. This morning, because of the gravity of this situation and the rush to hold the Attorney General in contempt, I wrote to the Speaker urging him to intervene directly and personally. Attached to my letter and to my statement there today is a list that my staff compiled describing more than 100 errors, omissions, and mischaracterizations in the contempt citation we voted out of our committee last week. Since some of these flaws are simply misleading, but others are significant legal deficiencies and factual errors that call into question the validity of the contempt resolution itself. For example, the resolution rests on an obvious legal deficiency. It would hold the Attorney General in contempt for failing to produce documents that were never demanded by the committee's subpoena. The resolution covers a time frame from February 4, 2011, when the Department of Justice sent a letter to Senator Grassley initially denying gun walking allegations, to December 2, 2011, when the department formally withdrew that letter. But the subpoena never demanded documents created after October 11, 2011, when it was served. Even more troubling, the committee learned that the administration was asserting executive privilege mere minutes before our business meeting started last week. Unlike previous committees before us, we did not delay our business meeting to carefully and responsibly examine that privilege assertion. Instead, the committee slapped together an amendment that said the privilege was invalid on its face. Members of the committee, the last committee chairman who tried to hold an Attorney General in contempt of Congress was Representative Dan Burton in the 1990s. That investigation was so widely discredited that even Speaker Newt Gingrich refused to bring it to the House floor for a vote. Even in the most recent example of contempt that we have, the United States Attorney investigation, House leaders negotiated for more than 200 days after the Judiciary Committee vote before it was finally brought to the floor. In this case, the Speaker has not met with the Attorney General even once. They have not had a conversation about this. I urge you to reject this rule, and I hope that you will vote against it, and that you will join me in urging the Speaker and our Chairman to set aside politics and engage in a good faith effort to resolve this matter. The Constitution requires nothing less.
Well, thank you very much, Mr. Cummings, and thanks to both of you for being here. I have no questions other than to say that I do know that, as Mr. Issa has just said, an attempt to do exactly what you've just described, Mr. Cummings, in your closing remarks, is in the process of taking place at this moment. We all wish that we were not here. This is not something that we take any pleasure in because, I mean, it is true. At this time, to get into an issue like this is not something that is desirable for any of us. I think that the reason we're here is a very clear one, and that is we've gone for this period of time, and Brian Terry's family has I believe, got a right to have some answers. And I think that that is the goal, is to try to bring to light information that would make this happen. And so I don't have any questions other than to say that assuming that we do proceed with this, one thing I will say to my colleagues in both the minority and the majority, we are going to do something that has not been done in the past cases. I mean, going back to 2008, the last time this was done with two officials from President Bush's White House. And we are going to have a full and rigorous debate. We're going to give every member, unlike in February of 2008, we're going to give every member an opportunity to vote as they wish on this issue, rather than just hear buying and passing this. And so it's up to this Rules Committee to ensure that members do have the opportunity and to have their voices heard on the issue. And that's one thing that I will recommend to the Rules Committee that we make an order. So thank you both again very much for being here. Mr. Sessions.
Thank you very much, Chairman, and welcome to both of you, Elijah. It's good to see you. Elijah, I heard your words that you gave. I also heard the gentleman, Mr. Issa, and his words of uncooperative. Mr. Chairman, I would ask you, you have, as the chairman of the committee, asked for and not received documents that you've asked for. Is that correct?
That's correct.
You have had the Attorney General to give testimony before the committee. Is that correct?
Yes, we have. And on that occasion, he said he would not give us the very documents we're trying to compel today.
This is, as I think our chairman, Dreyer, has stated, it's an unfortunate circumstance that we're all here. Mr. Chairman, do you believe that this Congress has forthrightly asked for things which you consider to be reasonable, and that you've given the Attorney General an opportunity to express himself, and he simply chose not to be, as you said, cooperative?
Thank you, Mr. Sessions. I very much do believe that we're asking, with the help of the Speaker, who on May 18th narrowed the scope of what we were saying would be subject to contempt, we're asking for the minimum that anyone on either side of the dais would ask for. Congress was told something that was untrue. Many people inside the Justice Department apparently participated for 10 months before it was corrected. We were told the truth. We want that information, both how they came to tell us something untrue and, of course, what led to the admission. The ranking member is correct. We have not issued an additional subpoena for that period post-October, although I think in the regular course it would seem reasonable that we would that they would produce all or nothing. I might note, though, that in the reference that the ranking member gave to the ATF director in that 2 days, 4th and 5th of July last year, when Republican and Democratic investigators had the ATF director in a sworn environment, he explained that the reason he didn't know was that the information he gleaned that let him know about gun walking came from sealed wiretaps that were part of DEA's request and part of this OCDETF. In other words, a combined task force over which he did not control, but the Justice controlled. So although the ranking member is correct that the ATF director said he was not aware of the gun walking, it was clear within these wiretaps that people within Justice that signed them off were, and that went all the way to the office of Lanny Breuer and some of his officials. I might, if you don't mind, correct one thing that my colleague keeps saying. I have never said, to the best of my knowledge, and certainly would not intend to say, that I had specific knowledge about what the Attorney General knew. What we've said is he is the custodian of the documents, including those that we seek, and that's the reason for the contempt, is his refusal to allow us to have access to these documents, except in a, as he sees fit, a few documents in return for dismissing the contempt, something that I think has been widely and accurately reported.
Do you believe that the Attorney General has been given the option to provide in writing answers to the questions that you've asked, or is the committee making a demand that the Attorney General present himself?
We have never demanded the Attorney General present himself. We have asked for documents, and most of these documents, Mr. Sessions, specifically would support sworn testimony we've received before the committee. We've interviewed 24 witnesses on a bipartisan basis. The vast majority do not come directly before the hearing. Our intention, a number of the people that the ranking member has asked to have in those letters, we would like to have in front of our committee, but we need the documents. Otherwise, we'd be essentially re-asking questions without the substantiation in writing that they say exists.
Mr. Issa, do people in your committee have, not just members, but your staff, security clearances to where they're able to receive, review, and discuss top-secret elements of the United States government and items which might be before your committee?
A number of our people do, including one member who's the former staff director of the Select Intelligence Committee, have the highest possible clearances.
So you would consider that if a request came from the committee, that you would have the clearance necessary to properly understand and work with that information on a
Absolutely. We've actually
top secret basis.
We've actually asked for an in-camera review where we would just simply read the documents in an environment controlled by the Justice Department. They've turned us down on that also.
So in other words, the Department of Justice, who would and could maintain and should maintain a responsibility for privacy or secrecy under a top secret clearance element, you believe that you have asked them and been denied those opportunities to receive the information?
Yes, sir.
Out as it stands. Good. Thank you very much. I want to thank both of you for being here. Mr. Cummings, is there anything that I've failed to ask?
Yes. Yes.
I would like to ask.
Yes,
I would like to the same line of questioning that I think that I gave to the chairman, the gentleman,
Yes.
Mr. Cummings, and I know that we've served going back in 1997 on subcommittees with each other and worked very carefully. We're very good friends. You know, you have a relationship with me as I do with you about wanting to get to the bottom. Is there something further that I,
Yes.
under the line of questioning
Sure.
that I had?
Just one thing.
Yes, sir.
This piece of this has been left out. The issue has come up as to what happened with how that letter came about, and the letter of February 4th. The thing that February 4th, 2011. The thing that the chairman did not say is that the Attorney General delivered to the committee 1,300 pages of what's called internal deliberative documents that was to explain exactly how that happened. As a matter of fact, as I understand it, the Attorney General was so upset about that letter, the letter of February 4th, those documents were given to the chairman and to the committee. And internal deliberative documents are quite often documents that executive privilege is asserted over. But I think, and I can't speak for the Attorney General, but in trying to cooperate with the committee, he did that. Now, keep in mind, too, that I sat in a meeting with the Attorney General and with Mr. and the Chairman about a week or so ago. Yep. And I heard the Attorney General say, look, I'm willing to give you certain documents, but I'm just asking, and he said, you know, I've got my Assistant Attorney Generals tied up looking through documents, taking up a lot of time when they've got a lot of work to do. I'd like to have a good faith effort that we will bring this contempt effort to some type of conclusion, a good faith effort. And basically he was told, well, you've got to produce the documents. And I guess what I'm getting at is, my concern is that if we are going to find in contempt, for the first time in the history of this country, a cabinet member, I could understand it a bit more if it were a situation where we had an Attorney General who said, I'm absolutely not going to do anything with you. I'm not going to work with you. Here's a man who has appeared 9 times in 16 months, produced 7,600 documents. We know what happened with regard to Fast and Furious. We know. We got that in the 7,600 documents. And so, but to hold somebody in contempt the first time in the history of this country when they've been trying, that concerns me, and I think it should concern every one of us. Of course, it's clear it has been argued by attorney generals over and over the years and others that certain accommodations need to be met. And I think there has been accommodations being tried by the Attorney General. I believe that we could try more. And that's why, as late as today, I wrote to the Speaker asking him to interject himself into this process before this moment in history takes place. I don't think it has to be, and I think we can do better. Our country is better than that. I think this is about, I hesitate to say that I believe that when history looks back at this moment, this will not be a pretty moment for this country.
Mr. Cummings, you had indicated in the beginning in your testimony that you felt like that you were upset and worried about the existence. Do you believe that you have received an answer to the questions that you might have if you were chairman, certainly as ranking member? Have you received the answers back that you needed?
When it comes to, let me put it like this. When it comes to the death of this young man, which is what, and I made a commitment to his mother and to his family, and I made that commitment within a week after I suffered a death in my own family.
Yes, sir.
Tragic death. I said I would not rest until we got to the bottom of this. The 7,600 pages that we've gotten, the emails that we've gotten, I think pretty much answers the question. I think we pretty much know what happened here. I do. And as far as this letter, I too am concerned about how a letter is written and how a letter comes to this committee that is not true. But I also am impressed with the fact that we had some people, this thing started under the Bush administration in 2006. In 2006, I want to answer to that question, to 2006, and we had a situation where over and over again, the same people who ran the operation from 2006 through Fast and Furious are the same people that sent the false letter to the Justice Department up here in Washington. I'd like to talk to them. I would like to talk to them and see what they had to say about it.
So you too have questions in your mind?
Yes, I do have questions, but I am convinced, Mr. Sessions, most respectfully, that this can be worked out. I've said it many times. You cannot convince me that I believe that, I've used this analogy, I believe that we're on the 1 foot line. And it's merely the Speaker joining together with the Attorney General. I think this thing can be worked out. I pray to God that it is worked out.
I'd like to correct the record on one thing. Our subpoena covers the period August 1 to 2009 till the present. It runs every day until January 3rd next year. So I was mistaken when I said that we would have some uncovered period. The subpoena is not defective. It does continue to run.
Well, I want to thank both of you. I have many questions myself in my attempt to not only look at the documents that have been received and the answers that come forth, but I will be very respectful to the attention that other questions that will come up, and I want to thank both of you for being here today. I yield back my time, Mr. Chairman.
Gentlemen, nice to see you this afternoon. I must tell you that I'm totally perplexed by this whole thing and what we're attempting to do today. To cite the Attorney General in contempt, in my mind, is not going to in any way make any of this any clearer to us. What is concerning to me is that the witnesses who really should know what happened here were not involved in these 16 months of hearing at all. First, I would like to know, the previous Attorney General did know about it. He was briefed thoroughly on Fast and Furious in 2007. As I understand it, was asked to expand the program. Now, we don't know if he said he would expand it or not because nobody's ever asked him, to my knowledge. But it did go on.
Ma'am, the facts don't support that. The fact is that Fast and Furious was begun under this administration. The linking to Attorney General McCasey, yes, Attorney General McCasey, what he received was a briefing on what ultimately was a different program.
There were 4 of them.
There were multiple different programs, as you would imagine there would be in alcohol, tobacco, and fire. But the program that he was briefed on the day he was meeting with his counterpart in Mexico is a program that had long expired, as had Wide Receiver and others, prior to this administration. Let there be no doubt, Fast and Furious was not begun under the Bush administration. Fast and Furious was a new and separate OCDEF created under that statute during this administration. Additionally, Wide Receiver, which had been by the previous U.S. Attorney declined to prosecute because it was a failed program, was reenacted under Lanny Brewer as the head of the criminal division and an attempted prosecution. Those were decisions all made under this administration. This is a little bit like your brother does something wrong, and then when you do something wrong, your excuse is, my brother did something wrong. These are very different occurrences. They have a similarity, and we do not condone what happened under the Bush administration. But understand, they're completely separate operations, and Fast and Furious was wholly begun under this administration with a U.S. Attorney, Dennis Burke, who was confirmed as a U.S. Attorney by an Obama appointment. No question asked, no ifs, ands, or buts, no possibility of misunderstanding.
Would Ms. Slaughter, would you just yield just briefly?
Sure. Go ahead, Mr. Hayes.
Then, Chairman Issa, if the 2006 matters that Ms. Slaughter brings up at this point, and Attorney General Mukasey was briefed, do you have any knowledge with reference to your now admitted that these are similar but totally different matters, that Attorney General Holder was briefed by alcohol, tobacco, and firearms before Fast and Furious began?
We can say that.
Me yes or no?
No, I have to explain a little bit. If we substitute.
Answer me yes or no.
I'd like to answer. Just take a second to make it clear. Lanny Brewer, head of the criminal division, is the person that we know and acted. He was aware of Wide Receiver. He acted because he thought those prosecutions that had been declined previously could be made. He dispatched somebody to attempt to resurrect the prosecutions that were abandoned under the Bush administration related to Wide Receiver. Understand, we're not without agreement that we have to continue to look at all these failed programs. However, whether it's Fast and Furious or the ones in the previous administration, the reform is separate from our investigation, and we do want that. I think Mr. Cummings and I agree that never again can guns be let to walk, nor can we have people robo-signing subpoenas so they can say they didn't actually see what would have shown them a problem in these wiretap subpoenas.
I appreciate that, Mr. Chairman. If the gentlelady would continue to yield. You absolutely did not answer the question that I asked you.
I have never, Elsie, I've never said Eric Holder knew anything in specific. That has been part of the misunderstanding. I've never called for his resignation, nor have I specifically said that he had information. Just the opposite. He is the man responsible today for getting us the answers about who did, and if those people need to be terminated, transferred, or reprimanded, doing it. And that's something that he saw when we had what he described as a fair hearing before our committee. We're holding him responsible to fix what was broken. I've never called for his resignation nor said that he had specific knowledge. The question is, what is being done to cooperate over the past and to hold those responsible accountable? Right now, people are not fired, not reassigned in any great numbers, and there's a lot of people that we believe were part of it. And Mr. Hastings, I absolutely agree with you that people who recklessly say somebody knew without a piece of paper or some substantiation should not be saying it. And most of the statements you've heard of that sort, they come from off our committee.
Mr. Hastings, just one quick thing,
Yes.
Ms. Slaughter. We had concerns, Mr. Hastings, about if somebody did that to me, if they lied and sent me something, then I sent it somewhere else, I'm going to fire them. We had questioned the Attorney General about that, and he said that most of these people have been transferred and moved around, but they hadn't been fired because he's waiting for the IG report, by the way, which he ordered. He ordered the investigation when he found out about these tactics and ordered the IG investigation. Now, and that investigation is supposed to be complete, I think, sometime in July.
Is that the reason why we're in such a rush now to go ahead and complete this contempt citation?
I don't know why we're in a rush. I think
Well, I do. Obviously, this is an emergency meeting last night. I think the civil contempt was just written last night. We've hardly had time to even get prepared for this meeting today.
Ms. Slaughter, it's been almost 4 months that our contempt information has been out there. It's not new.
Mr. Issa, you also said as recently as Sunday that you didn't have a scintilla of evidence at that committee that this administration, either Holder or the president, have done anything wrong.
Ma'am, I'm afraid that your characterization is very wrong. What I said in response to Chris Wallace, what I said in response to a specific question, do you have evidence that they knew? This was related to
Your answer was no.
And that's correct. And understand, this contempt, we are not holding the president in contempt. We are holding the keeper of the documents in contempt for refusing to deliver documents about who knew we were lied to and who kept it covered up month after month. Some of you, like my colleague here, are attorneys. Attorneys do have a duty of candor. You can't allow a false statement, a lying to Congress, sit out there where you know that Congress has been lied to month after month after month. We believe at a minimum, based on documents, that as early as August, some people, particularly inside the Justice Department, knew we were lied to and continued with that cover-up while Brian Terry's family was still waiting to hear at least that their son had been killed by gun walking when, in fact, he was.
Well, as far as I'm concerned, what you said Sunday meant that what you were doing here is you want more documents to try to see if you can find something.
No, not at all. The documents that are being held in contempt, the documents in contempt do not seek documents or communications with the White House. Just the opposite.
Then please explain why it is that you refused to allow the Democrats in all this time to have a single witness, why you didn't at least call in former Attorney General Mukasey, why you have not talked to the head of the Phoenix ATF, who certainly knew everything and seemed to have operated all on his own, as far as I can tell from what I know about it.
Well, Mr. Cunningham, who is one of the knowledgeable people, is saying he's going to take the
Talk to
fifth.
the head of the ATF. And frankly, what I'd like to know as a member of Congress is why anybody would do that thing 4 times. Why you would try to go have guns and see if you could find them again. It sounds like a child's game. It's a crazy idea. And but why in the world you don't want to know that? That's what troubles me.
Ms. Slaughter, the
What you're trying
issues.
to find out is what you can to cast aspersions over on Attorney General Holder, who basically just got to town, manner of speaking. As far as
Well, 3 years out of 4 years of a presidency is a long time.
As far as this program is concerned.
Ms. Slaughter, the 80,000 documents were given to the Inspector General. The Attorney General says he has 140,000 documents total. The fact is that we have been denied 70-some thousand out of 80,000 documents that the Inspector General himself has been able to get, first herself and now himself, have been able to have access to. So we have not been given the kinds of documents that were allowed. None of those documents that we've requested are intended to be communications to the White House. So the Attorney General is only the subject today here because there's a refusal to grant documents, not because he is the object of an investigation. And we've made that clear all along.
Stan, you're not investigating.
Ms. Slaughter, may I just interject
Yes,
real
certainly,
quick?
Mr. Cummings.
Ms. Slaughter, I said earlier that 1,300 documents have been revealed, given to us with regard to that letter. Those documents clearly show that there was no cover-up and that these lies came from the field office, the folks who ran this
One in
show.
Phoenix.
Yeah, in Phoenix. That's correct.
Well, it's
We know that.
on your committee. Let me just throw this in as a colleague. That's the thing I'd want to be looking at. I don't understand why you're not concerned with the ATF, which seemed to me to be completely out of control. You didn't even call in the head of the ATF and ask him what he knew about this program.
We did have the head of the ATF, and we're perfectly willing to have him back. But in his sworn testimony, he asserted certain documents we are being denied. We would like to have those documents before we have him back so that the correspondence will be meaningful. Additionally, we did have the local individuals, both whistleblowers and other individuals, at earlier hearings.
Amendment?
Pardon me?
Did they both testify?
Cunningham, who has asserted that he will take the Fifth Amendment, has not been brought. But again, There are documents related to his correspondence that before we have them in front of our committee, we would certainly want to have those. Now, I don't know about every lawyer on the dais or every lawyer in the world, but from what I can glean in my years of working in this body as an investigator is that you do not invite people up and ask them haphazard questions. If there are documents that would help you ask accurate questions, ones that can be substantiated as to their truthfulness, you want them. That is what we're being denied. Again, Ms. Slaughter, I know there's a lot of things being said, but the narrow question before you today is about the refusal to grant us documents post-February 4th related to a false statement made to Congress and subsequent testimony and the period of time until it was retracted in December. That's the only thing that is before you in contempt. And as of May 18th, the Speaker narrowed dramatically to about twice that. And then after we received the wiretaps and were able to glean what was in them, it was narrowed further to this one issue. So the only thing new about this is it is much less of a request than it would have been months ago when we first realized we were not getting cooperation any longer from the Attorney General's office.
Well, I think in the future, this is historic. We've all made that statement. This has never been done before. So obviously, the attention, I think, of scholars in the future will be turned to it. That they can only surmise when they get through that it has all the trappings of a witch hunt. I regret saying that, but I must tell you that's my true feelings. Mr. Cummings, let me ask you a question. Yeah. In the last few days, you've had a chance to go over the report, and you have discovered about 100 errors. Is that correct? The omissions and the mischaracterizations. Let me ask you about a couple of them. On page 25, the contempt citation states that the committee's investigation into Fast and Furious is replete with instances in which the Justice Department has openly acknowledged that it would not comply with the committee's address. Is that correct?
Yes, that's correct.
And that's pretty serious.
That's pretty serious.
I agree to that. On page 2, the contempt citation states the Department of Justice has refused to comply with congressional subpoenas related to Operation Fast and Furious. Would you like to comment on that?
Well, one of the things that the chairman was requesting and were documents which were would have been unlawful for the Attorney General to produce, such as wiretap applications, such as documents that would reveal confidential informants, documents that might interfere with the trial. Keep in mind that the disclosing wiretap information has a criminal penalty attached to it of 5 years in prison. It's kind of hard to find, I think, to find somebody in contempt when they would be in criminal trouble if they did what they were asked to do. And that's an impossible task for the #1 law enforcement officer in the country. And so, so a lot of, when Mr. Issa talks about, Chairman Issa talks about cooperation, I think a lot of the discussions and problems surrounded things like that, where the Attorney General just could not reveal information. And by the way, the Attorney General made it clear. I mean, he wrote letters, the assistants wrote letters explaining those things to him.
But you would agree that that's outside the contempt request, that those wiretaps were long before that period of time, weren't they?
Yeah, and the fact is,
so they're not a discussion here today.
This has not changed until about a week or two ago. Up until then, he was complaining that he was holding back information and whatever, but he was asking for documents that he couldn't even produce.
Well, I really regret this day. I think it reflects very poorly on us as a citizen of the United States. I'm very much concerned about what happened here. I'd like to really get to the bottom of it. Who okayed that crazy mission? Why did they try it 4 times? I don't think in any way that we have done justice to Brian Terry with what we're doing here today. And that is a shame. But somehow the story, I'm afraid, here may never really be told. And I include in that the sending of an incorrect, false letter to an important senator of the United States. That needs full explaining as well. I'm grieved, and I understand that they're saying that they can't do anything without the IG's report, but that those people still work for the U.S. government. Frankly, I would really want to know everything that's happening in Phoenix. I'd clean that rat's nest out right away. But let me just say that the fact that not a single Democrat witness was ever allowed to publicly testify before that committee. Is that correct, Mr.
That's
Thomas?
right.
10 requests to call Ken Melson, the former acting director of the ATF, was not allowed. The refusal to call former Attorney General Michael Mukasey to publicly testify, even though he knew in 2007 that he was briefed on the gun walking operations. I don't think these are signs of a serious investigation. I don't see how anybody can think that they are. But we continue with the latest chapter in a scripted sideshow, frankly. I'd like to see this really investigated without all the political tinges, because we need to know what happened here. It's a very serious business. We still don't know where those guns are. We don't have any idea how many people have been killed with them, or they've been used with crime. But this is, to me, is just another spectacle that I'm sorry, sort of like spending all the months we did debating light bulbs. I yield back.
Joan, yield your time back.
Thank you, Mr. Chairman. And I want
Virginia, are you sorry you left the committee?
Well, I don't know, Daryl. It's this one state keeps me pretty busy, and there's a lot going on here. Mr. Isaac keeps offering me come back.
There's a spot waiting, Mr. Chairman.
I do love serving on the Rules Committee.
But you're just on leave, just on leave.
But I appreciate the work that you're doing, and I want to commend you and the staff of the Oversight Committee for the work that you've done under your chairmanship. I think you have been very judicious, and I think you have done the work that the American people expect us to do as members of Congress, and that is to hold accountable anybody in the federal government that needs to be held accountable. I talk about accountability a lot, as my colleagues will tell you, and I think that's our job. I want to say that I think there are a lot of things been thrown around here, as you said, that are extraneous to the issue at hand. This is about the truth. And that is the point that needs to be made over and over again. We're not engaged in gamesmanship. We're engaged in getting the truth. Even Mrs. Slaughter said she'd like to know the truth. Therefore, I think that what we do as members of Congress is all that we can do to get to the truth. And there's bipartisan support for getting to the truth. And I believe that there will be bipartisan support tomorrow for this. Do any of us like this? No. I don't know anybody who takes any pleasure whatsoever. We love our country. We love our form of government. We want it to work well. And it's not working well right now. So we have a duty to perform, and that's why we're here. You know, I go to a Bible study every Wednesday morning, and it's really ironic. This morning, our leader led us into the discussion of compassion. That was our topic today, and I thought how ironic that that was the topic, and I actually brought my Bible study material with me. Compassion is defined as a feeling of deep sympathy and sorrow for another who's stricken by misfortune, accompanied by a strong desire to alleviate the suffering. Mercy and tenderness. Now, I think that the Brian Terry family deserves our compassion. I think the families of the 200 or so citizens of Mexico deserve our compassion. And that's been left out. I never hear any of my colleagues talking about those innocent people who have been killed as a result of this program. And I would like, Mr. Chairman, if I could, to insert into the record an article from the San Diego Union Tribune And I'm going to read a piece
Without
of it.
objection, they'll be entered to the record.
Thank you, Mr. Chairman. It sums up the choice before Congress regarding Fast and Furious as such, and I'm quoting, "What matters ultimately is this simple narrative. Many people, including a U.S. Border Patrol agent, died because of a U.S. government program. The Justice Department was caught lying about its oversight and handling of the program. Congress wants to know why. Holder says he's done nothing wrong but won't provide the very documents that would establish his innocence. So why would the Attorney General and the Obama administration act in such a fashion? A logical conclusion, they have something to hide." End quote. That's exactly the way it seems to the victims of this failed government policy. So I'm quoting again. "For more than 18 months, we've been asking our federal government for justice and accountability," write Kent and Josephine Terry, the parents of fallen Border Patrol agent Brian Terry. "The documents sought by the House Oversight Committee and associated with Operation Fast and Furious should be produced and turned over to the committee. Our son lost his life protecting this nation, and it is very disappointing that we're now faced with an administration that seems more concerned with protecting themselves rather than revealing the truth behind Operation Fast and Furious." I think that the entire Terry family and the Border Patrol agents who served alongside him deserve to know the truth. And we need to know why there were lies told, who told them, who knew. And I think it's a tragedy that this government, their government, has embargoed the honest details for so long. It's the right thing to do, the compassionate thing for us to demand openness and transparency on their behalf and on behalf of the American people. So I want to say that this is not anything anyone delights in, and that it's very important that those of us here show our compassion. And to me, Mr. Cummings, getting to the bottom of this is the compassionate thing to do. Now, I have a question I would like to pose to you, Mr. Chairman. I'm very concerned about the assertions being made over and over and over again that this program began under the Bush administration. This article in the San Diego Tribune points that out. This did not begin under the Bush administration. I heard this timeline a couple of days ago, but I wonder if you would mind, for anybody paying attention to this today, to explain a little bit about the program that was held under the Bush administration, and as I understand it, was ended in 2007. And then this program that was begun and operated totally under the Obama administration. If you would, in a fairly succinct way, give us that information and then make comments on anything else, particularly the misleading statements that are being made over and over again. Thank you.
Thank you. First of all, in order to be thorough but succinct, Attorney General McCasey was not briefed on wide receiver. He was briefed on a much smaller failed program because he was going to meet with Mexican counterparts and wanted to be able to talk to them. And the previous programs that involved guns potentially going over the border were all, under the Bush administration, were all done in concert with the Mexican government. Now, I'm going to tell you here today, from what I can tell, they were all flops. They were all failures. None of them, I believe, ATF should point out as the right way to do it. Even the one that has been promoted lately, Fernandez, where one of our whistleblowers was involved in trying to get not an export to another country, but somebody who was buying weapons without being a federally licensed gun dealer and was enhancing them, put additional accessories on, and then reselling them on the Internet. ATF did not provide him sufficient resources, so after a long stakeout, he finally had to abandon this straw buyer's or this reseller's residence, and ultimately no prosecution occurred. Any and all of these are examples that we should not allow to continue. Either pull the guns immediately, which is the ATF's job, is to take guns out of people's hands. It's actually not to do prosecutions. It's to take guns out of people's hands that shouldn't have them. That has to be their job. We in Congress have to see that justice gets them back to that. Having said that, as you said, under the previous administration, the large program, the program I think we've all become aware of, Wide Receiver, was responsible for hundreds of weapons attempted to be moved in a way in which they would have followed them to the handoff, failed. Additionally,
It's my understanding they had a tracking device in them.
they had a number of things, including handoffs on the other side of the border and so on. But let's understand, that program, ultimately by the U.S. Attorney at the time, a Republican appointee, was determined not to be a good tactic for prosecution. And they decided to close up the program, to cease it, and in fact not to do prosecutions. That ended, as you said, in 2007, well before the election, well before Senator Obama became president. Now, having said that, there is a link, and that is in 2009, virtually at the same time as Assistant Deputy Attorney General Lanny Breuer, the head of the criminal division, was sending people to reopen the prosecution, the possible prosecution under Wide Receiver. Fast and Furious began. Fast and Furious is part of an OSINDEF, if you will, a joint drug task force. DEA, Justice, including the U.S. Attorney in the area, ATF, even ICE agents were all part of this combined task force. And that is ultimately the reason that although ATF bears a great deal of responsibility for these failed tactics and for the people who promoted them, ultimately the chain of responsibility and reporting went through the U.S. Attorney, up the chain all the way to people in Washington. Additionally, DEA had a major role in this, and they were part of a number of surveillances, none of which are germane to today, and all of which I believe should remain confidential because they are, in fact, law enforcement sensitive as to how they did it and, quite frankly, what they know when there are ongoing prosecutions. But your point is exactly right. Mistakes made under a Bush administration, whether they went to the then Attorney General or not, were mistakes. This particular mistake takes people who knew about Wide Receiver, including, apparently, Lanny Breuer, and reopens and expands the same tactic. And that is really one of the reasons we're here today, is that when you know about a previous program and you, in fact, at high levels of justice, embrace and continue and expand, then ultimately you own that mistake. So I am here today to say my committee will not rest until we look at the entire history going back, but only for the purpose of making sure it never happens again. And I think all of you are going to see a rule someday that changes ATF's very organization come out of our committee, because I'm convinced that the current organization is not sufficiently commanded and controlled in a way in which we can rely on their doing the right thing in the right way. So I think your point is exactly right. Narrow today, it's only about one program opened under this administration, and it isn't even about the program or the operation. It's about the refusal to tell us the details about the post-lying events.
Thank you very much, Mr.
Thank you.
Chairman. I appreciate it very much. Mr. Cummings, thank you for being here. I don't have any questions for you, and I yield back, Mr. Chairman.
Thank you very much, Mr. Chairman. I want to thank both the witnesses. You know, I think this is a dark, dark day for this committee and for this House. This is serious business, and we need to take it seriously. And, you know, the fact that we are bringing this resolution to the floor, a contempt resolution, the first time in the history of our country that we're going to hold an Attorney General, a cabinet member in contempt, you know, I think should give everybody here a little bit of, should give everybody here some pause. This is not about gun walking, because those documents have already been provided. This is not about understanding why the department sent the erroneous letter to Senator Grassley, which we all deplore, the fact that any misinformation would be sent to any member of the House or the Senate. But it's not about that, because those documents have also been provided. This is not about negotiating a solution because the Attorney General has already offered to provide a number of documents that are in question, as Mr. Cummings has pointed out. And this is not about an even-handed investigation because, as was pointed out by Mr. Cummings, the Democrats weren't even granted one witness. I guess, Mr. Chairman, I'd ask you, I mean, I know this has been asked by Mrs. Slaughter, but is it true that you never granted any Democratic requests for witnesses through the entire investigation?
No, it isn't true. Ultimately, for most of the hearings we had, they requested no witnesses. For example, when Bill New and Dennis Burke, both local Phoenix individuals responsible for Fast and Furious, they did not add any. Early in the case, we brought whistleblowers and responsible parties before the committee. They asked for no additional. It is true that former Attorney General McCasey was asked, the minority asked for him at a time in which we were having the Attorney General. Since we were narrowly focused on the Attorney General and narrowly focused on a period of time that had nothing to do with his predecessor, I declined that invitation. Additionally, it is not common to have current administration officials in with former administration officials. When it comes to the former ATF director, I do want him back, and have said I will have him back.
This seems contrary to what Ranking Member Cummings said in his testimony, that Democrats have been repeatedly denied witnesses.
We've been asking for Mr. Melson. Mr. Melson is a very, very important witness, and Mr. Melson has said, that is, now he was the acting ATF director. He has said in his testimony before, like in private, that before staff, that he knew nothing about the gun walking tactics, and he never revealed any of that to anybody higher than himself because he didn't know about it.
So the Attorney General, am I right, has testified 9 times before your...
Not before Congress, 9 times before
He has
Congress.
testified before
16 months.
Appropriations, Judiciary. He's testified exactly once in which he was brought for this purpose.
Why wouldn't you have the head of FTA testify even once?
ATF.
ATF, I'm sorry, ATF.
It's a very good point. We had the former chief of ATF, and he is still a government employee. We had him for 2 full days on a bipartisan basis in which he was asked every question we could come up with. In that testimony, he said under oath that, in fact, he had sent an email after he read these wiretaps, which we now have possession of. They're not widely available, of course, that, in fact, he became sick to his stomach when he realized they had been gun walking. That is one of the documents before you today as part of the contempt. Before we have him back before a committee, we want to read that chain.
But that testimony you're talking about was not in public, was it? Was it before the full committee, or was it a private meeting?
That testimony before, well, look, when you have, just so we understand,
Right.
A public audience doesn't get to ask questions. The fact is that entire 2 days of testimony is available. The ranking member can put it online today if he wants to. It can be used. None of it was classified. All of it could, in fact, be used and put out there as factual sworn. So the only thing that wasn't there is members able to, in fact, grandstand before a person who was not he was a U.S. attorney in the previous administration. He had no knowledge and was not involved in earlier activities. We do intend on having him, but let me just give you the example.
I'm going to yield to the gentleman from Florida for...
Mr. Issa, the 2 days that you talk about, was Chairman Cummings or his staff in the first day of those 2 days of interview?
Yes, sir.
No, that is not correct. We didn't even know about it.
Was
We
that
didn't even know about it.
was that the day of July 3rd, the first of all those interviews?
Make it clear. He came in voluntarily because he was being thrown under the bus, in his opinion, made a scapegoat by the Attorney General. No, I'm answering your question.
Just a minute.
And
I just asked you,
I'm
you
correct.
said something entirely different.
Mr.
when
Hastings.
I asked you whether Mr. Cummings was in that first meeting on
Mr.
July 3rd.
Hastings, when he was sworn in, after he came in voluntarily to explain his story, we did not subpoena him. When he came in, we asked, would he have a full meeting? He then had a full access of the ranking member staff. His Democratic staff.
On the 4th of July.
What day was it? On the 4th of July, both majority and minority
And
shaking
when he
hands.
was with you, when he voluntarily came in, was he sworn?
No, he was not.
Thank you for you.
But he was sworn. Okay, it's a false statement. You can't lie to staff. I'm being told he would be under the same criminal allegations, as you know, if you give false statement to members of Congress. But just so we understand, and I want to make sure that you get something, there's another individual whose name hasn't been mentioned here that we would have on the same panel, several others. Jason Weinstein, Kenneth Melson, and Patrick Cunningham, and Hurley, for example. These are all people that I know the ranking member would like to have. We would like to have them. But from a deposition or a interview done on a bipartisan basis with Jason Weinstein, we were told in that, and this is one of the reasons we're here today, we were told about a document that Jason Weinstein had prepared, and he said, my recollection, it's been a long time, that it was 3 or 4 pages, and it was an analysis of the case reflecting that he had interviewed Cunningham, Hurley, and then walked through the case and how it went about and issues with the case. Okay? He's talking about a 4-page memo that he wrote as an email. In the weeks in the weeks after February 4th, he conducted this. So Weinstein says in this interview, okay, I didn't write the memo. I wrote an email summarizing what those gentlemen told me. Okay? Investigator says, okay, what did that email say? DOJ attorneys, our attorneys of justice said, he can't answer that question. Weinstein, okay, it was after February 4th. Investigator, okay, so you're not going to answer my question? DOJ attorney interrupting, he can't. Weinstein, as I said, I can't. That memo, 4 pages, prepared shortly after February 4th, when we were saying this is an outright lie, we were saying something's inherently wrong with this. We have a whistleblower saying there's gun walking. They dispatch one of the top people. He does a quick investigation. He produces a memo. He wants to testify to it. DOJ says don't talk, don't answer their questions. In other words, they obstructed right in front of us. We're asking for that document. Right. Now, that document's not all that deliberative.
Just going back to the ATF, so you didn't have the ATF officials in a hearing because you were concerned about grandstanding? Is that why? Is that what you said? I mean that's the new definition of irony.
Well,
I'm just repeating what you said to me. That you know,
look, we had Phoenix-based ATF agents available. This gentleman from Washington has testified, and we would have him back again. But we are not easily going to have somebody back again when there are documents that are being withheld that would allow for a sensible set of questions. Again, there's no reason to have somebody in 5 or 6 times when the people who could allow you to have it in are denying us the documents. We have no problem with having Kenneth Melson back in. We're certainly willing to. But again, he's told us things that exist. We're asking for those things, and we're being told we can't have them.
It's been what, a week since you reported this contempt resolution out of your committee? I mean, what is the rush to bring this to the House floor? I mean, we have an emergency meeting here in the Rules. We have an emergency meeting here in the Rules Committee. Minority staff on the committee have found in a few short days that the report has been made available. They've found 100 concerns with the majority report, I think we all, I don't care. What party we're with. Well, I think we're all interested in making sure that whatever comes to the floor represents accurate information. And the minority staff has found 100 areas in the report in which they raise concerns about whether they're factual, whether they're accurate. And again, given the fact that the Democrats have been denied again and again the opportunity to call witnesses, I think it's incumbent upon the Rules Committee, I think it's incumbent upon the Speaker, to approach this in a more rational way. You know, I mean, again, I mean, I'll ask Mr. Cummings, this is on page 22 of the report, the contempt citation says, and I quote, "Because the department has not cited any legal authority as the basis for withholding documents pursuant to the subpoena, its efforts to accommodate the committee's constitutional obligation to conduct oversight of the executive branch are incomplete." Is that an accurate?
Well, it disregards the fact that the department repeatedly cited the executive branch concerns and its legal authorities in numerous letters to the chairman. I mean, whenever something came up, they made it clear as to why they were not able to do it, and cited legal authority.
Yeah, again, I'm just puzzled that we're doing this contempt resolution, and the head of the ATF has not testified publicly before the committee. It would just seem to me that it would be, we would want to hear his testimony before this thing comes to the floor. I mean, this is a terrible tragedy happening, and what I see happening is you're compounding that tragedy. I really do agree with Ranking Member Slaughter. I mean, this looks like and smells like a witch hunt to me. I mean,
Well, that's been the Democratic talking points all along.
I mean, this is. I mean, as I get deeper and deeper into this, and I learn about all the documents that have been released, and I learn about the willingness of the Justice Department to continue to cooperate. I mean, this idea that we're, you know, in the Rules Committee with an emergency meeting to rush this to the floor tomorrow, just doesn't smell right to me.
Well, Mr. McGovern, as late as yesterday, the Attorney General Attorney General's folks presented even more documents to Mr. Boehner's staff, Ms. Ice's staff, and my staff. Again, trying to come to some type of agreement so that he could accommodate us and so that we could get what we wanted. I think basically the Attorney General has just come to a point where, you know, he's saying, well, where does this end? He's not asked for an end to the investigation. He's just trying to say, okay, what am I going to?
I think what he's trying to figure out is whether to keep on moving the goalposts.
Yeah, right. Not keep moving the goalposts, moving the stadium.
Right.
We keep moving the goalposts closer, and he can't seem to kick a 2-yard field goal.
Well, you know what? I mean, again,
We could lower it down so he could walk over
I think
it.
what is happening here today is divisive, and I think it's destructive. I don't think this is about truth to justice. It's about politics, and I think it's a cynical maneuver, and I think it is a disservice to this institution and a disservice to the American people. We're all interested in the truth, and I think we're getting to the truth about what happened and what this botched, this botched ATF mission, which. I think we all have anger over these gun walking programs, and that's one thing. But what we're doing here today is going way beyond that. I'll say it again. I think we're doing a disservice to this institution. I hope the Speaker of the House reads your letter very carefully, Mr. Cummings. And I hope, and I never thought I'd say this, but I mean, Newt Gingrich had a right when he intervened, when Mr. Burton tried to do something similar. I hope Speaker Boehner does the right thing, and and we try to figure out a way to get to an accommodation rather than to this confrontation, which I think is a horrible precedent.
Thank you, Mr. Chairman. Thank you both for being here. I'd like to read a brief prepared statement, Mr. Chairman. What we're doing here today is protecting the Constitution of the United States of America, which all of us are pleased when we come here to raise our hand and swear so to do. It is critically important that we protect the powers of Congress of the United States for future generations. It would be dreadful if a future president, having looked back over the recent events, used it as precedent. We have a strong case on the merits, is the first point I want to make. We win the executive privilege argument, both on legal grounds and our compelling need for the requested information. Aside from prevailing on the merits of the executive privilege dispute, enforcing our subpoenas is part and parcel of our ability to perform effective oversight. If we accept the White House stonewalling in this instance, the House in the future will not be able to conduct its oversight. And every future president can view Congress not as a co-equal branch of this government, but as a subordinate to the executive. If we countenance a process where subpoenas can be readily ignored, where privilege can be asserted on the thinnest of reeds in the broadest possible manner, then we have already lost, and we may be in much more danger than even we believe. Mr. Chairman, that prepared statement is not my words. It's the words of the ranking member when she stood on the floor of the House on February 14th, 2008, in the last contempt process this House went through. And I think her words were as true then as they are today. It is beyond me how this has become a partisan discussion and a discussion about the merits of an investigation and not a discussion about whether a co-equal branch of government is responsible to accede to our subpoena power. And I'd be happy to yield to my friend.
I appreciate it because I see this is entirely different. What we have here, in my view, let me make it clear, this is my opinion, was not an attempt to find out what happened so that Brian Terry's parents could have some idea of what happened to him. It was a way that we could get to the Justice Department and through him to the President of the United States. If you had wanted to do a serious investigation, I don't think there's any question, and I don't know how anybody in the world could even give pause to the notion that you would certainly have had the ATF in there publicly. You would have had the people who headed up the Phoenix station in there to find out what happened. You would want to know what went on previously, but there's none of that. That was just all jumped over. And not a single Democrat witness was allowed to speak at any of those meetings that they held. I can't seriously take that. I'm sorry.
I would say to the gentlelady that
I know Mr. Issa works very hard, and I know how dedicated he is. But I don't believe this could ever masquerade under the guise of any kind of serious investigation to find out what happened here. You haven't talked to the people who were responsible for it.
I would say to the gentlelady
then don't come to Rules Committee.
that this is not a Rules Committee meeting on the merits of this investigation. This is a Rules Committee meeting on a contempt resolution when a member of the executive branch is not responding to a duly issued subpoena. And I would say, because you and I have not studied these issues, I would say to my friend, Mr. Cummings, I understand all of your complaints about the way things have been handled over the last 18 months. If I'm ever in the minority, I'm going to have some complaints about the way things are being handled too. But my question to you is there one document that a duly issued House subpoena has asked for that the Attorney General could produce today, but he has as of yet been unwilling to do it? Is there one?
I'm sure there may be, but let me just try to. Wait a minute, hold on.
I'll come
let
back
me
to
answer
that.
your question.
I'll absolutely having answered.
Because I want to be real clear
Right.
with you. I don't want you to. I don't want you to
Having
what
answered my
happens in our community.
Right.
I want to be able to answer the question.
I'd love to find out. They put us here on this committee of exclusive jurisdiction. You better believe I'd love to be over there serving.
And by the way, I can answer that
we
question
had-
if you'd like.
But if there is one, my question is, why aren't you, as a member of this body, as am I, why aren't you in strong support of having the executive branch respond to our duly issued subpoena? This is not about trying to embarrass the Attorney General. This is not about trying to pivot a Republican group against a Democratic group. This is about trying to defend the rights and privileges that the people of the United States have entrusted to us, and the gentlelady was absolutely right in 2008. If you allow Republicans to go easy on Republicans, the Republic suffers. And if you allow Democrats to go easy on Democrats, the Republic suffers. We are not sent here to be Republicans and Democrats. We are sent here to be stewards of the United States Constitution. And I ask you sincerely, if this is a duly issued subpoena, you may wish it hadn't been issued. You may not like the circumstances under which it was issued. But if it is a lawfully issued subpoena, why aren't you standing here in strong support?
Because I'll
Please.
answer that. It's not a question of standing in strong support or not. I said to Mr. Issa, and I've said it over again, when I became the ranking member, I wanted our committee to operate just a bit lower than a federal court. I wanted to have integrity. I wanted to have fairness. I wanted, when something came out of this committee, for people to feel comfortable with it. That's what I wanted. I have not seen that. Now, I have been consistent. When I I've joined Chairman Issa with regard to subpoenas. Most subpoenas we found out about after the fact now, by the way. I have no problem with that. But there's another piece of that. I want this institution to be strong. I also want the executive branch to be strong. That's part of our duty too. When I see accommodation, when I see the Attorney General trying to work with us, don't keep in mind, it's not somebody saying, I'm absolutely not going to do what you've asked me to do. He's produced 7,600 documents, gone through millions of emails, appeared 9 times before the Congress of the United States, ordered IG investigation, done all kinds of stuff. And all I'm saying is that we are very close to being able to maintain the integrity of both institutions. That's what it calls for. The Constitution calls for an accommodation of each other and respect of each other. And so I don't think that what the Attorney General has asked for, that is us to continue to try to work this thing out, is undue. Nor do I think much of what Mr. Issa, Chairman Issa has asked for is too far out. What I'm saying, though, is that there's a way that reasonable persons should be able to agree to get this done. It's not my way or the highway. That's not how we operate.
I couldn't agree with you
And
more.
there's one other thing. Keep in mind what I said a little bit earlier, and I think you'll really respect this from what you just said. 1,300 documents were given over and above what was even asked for. And the Attorney General said, I'm willing to give these other documents to you, and more than what you've asked for. All I'm asking for is some respect with regard to this contempt situation. That's all he's asked for. And asked for a good faith effort to bring it to a resolution. And all I'm saying is, I think that what we're doing here, we're gonna find in contempt the highest ranking law enforcement officer in the country, when there has been an effort to work with the Congress. That concerns me. I just think, again, keep in mind, in the past 6 months in the Myers case, the U.S. Attorney firings, 6 months elapsed between the time we voted contempt out of the committee and the time that it went to the floor. 6 months. This is a matter of a few days. And I'm just saying, I just think that when you consider what we're dealing with here today, the fact that the Attorney General has done what he's already done and willing to do more as late as yesterday, I just think that this is just a bit much for that. And I think it deserves a little bit more time, that's all.
Yeah.
Mr. Woodall, to answer your question, yesterday, representatives, including of the Speaker's office, joined with my staff, and we went to the White House. We were told that they wanted to try to bring this to a successful close, and they implied there'd be something new. What was new was there were approximately 30 pages of selected documents from what we now understand to be about 200 pages that would be a complete and total, if you will, end of this case. The quid pro quo that has been repeatedly offered is that this has to satisfy subpoenas. The documents which were quickly briefed and shown in front of our people, they were not allowed, they had to put their notebooks down, they weren't even allowed to take notes about what they were being shown, included, apparently, from what the briefing said and our folks quickly were able to glance at, the Weinstein memo of 3 to 4 pages, something that undeniably is responsive and does not fall within any reasonable, because remember, they were investigating a false statement to Congress. They were interviewing the people responsible for the false statement, including people that we have had before our committee. That document was not available unless we took the deal. On the Speaker's staff's part and ours, we mutually agreed that there was no deal possible because it was a deal without sufficient documents to answer the important questions that clearly were still there.
I just want to make sure I understand you, Mr. Chairman, because I know Mr. Cummings was laying out a very persuasive case for how accommodating the office, the Attorney General, had been in trying to work with you. You're saying that the information that you have been seeking, they had there for the first time that you had ever seen it, and they, rather than giving it to you, they said, we will only give it to you if you agree to all of these preconditions.
That's the deal.
About giving it to you?
That's the deal. And ultimately, I know the ranking member characterizes 7,600 documents as a lot, or 7,600 pages, I should say. Many of those pages were blacked out. I have a hard time counting anything in which it is completely obstructed as counting. So you take hundreds of pages off for that. Almost 2,000 of them were related to wide receiver. Fell within our subpoena because we wanted to know about gun walking, and wide receiver we would certainly say was a failed program of what we would call bad controlled delivery or gun walking. No question. But when you actually look at Fast and Furious, you're now down to a few thousand documents out of 140,000 documents by, or pages probably, by the Attorney General's own statement, 80,000 given to the Inspectors General. The point, though, is the documents we have been given have been selected by, and it's less than 10% of the responsive documents, by the Attorney General's people, and they've given it to us. Quite frankly, they've given us documents that disproportionately prove their case. Now, I don't want to raise the stakes artificially high, but if we had finished Nixon at 10% of what he wanted to give us, we would still have had Nixon serving out his term. If we had taken 10% of Iran-Contra, we wouldn't know how foolish and failed that program was. At the end of the day, Congress has an obligation to understand the documents they want to give you and the documents they would love to see burned in a pit somewhere. We have an obligation to, at least on an in-camera basis, review them. We have tried to work, and the ranking member mentions this, we've tried to have accommodations. We've said, give us a privilege log. Show us what you're not giving us by description, so that at least we can know it exists, and then we can have a discussion about whether or not it falls under privilege. They've refused to do that, and that's part of the problem, is you can't end a discussion based on we've given you what is responsive. They've given us what shows their side of the story. We need to see both sides, at least in camera.
Mr. Woodall?
Yes, sir.
May have a breakthrough here. I'm not sure. You know what a privilege log is? A lot of this research hasn't even been done yet. And, of course, with a privilege log, you've got to identify the documents you're not giving, and then describe them, and then tell why you're not giving them up. Is that a fair description?
That's a fair
Okay,
description. And the Attorney General said he'd identified all the documents in live testimony before judiciary.
And so it's my understanding that would take some time to do that. I mean, it's my understanding. Again, I wasn't there, so I don't know. But I'm hoping that maybe you see, we're not that far apart, is what I'm saying. And I think this is a very, when you're going to find somebody in contempt, and it's the only cabinet member in the history of the country to be found in contempt, it seems as if we should be able to work something like this out.
Gentlemen,
I'd be happy to yield to my friend.
I just find all this very fascinating. Mr. Issa said that he wasn't calling for the Attorney General's resignation, then he invokes Richard Nixon. But putting that aside, I just want to say one thing.
The similarity is
I want to say
undeniable.
one thing here, and that is that is apropos to this committee. And that is, we're the process committee, and process matters. And when the process is flawed, I think it's flawed in your committee, Mr. Issa, the fact that Democrats were locked out, shut out in terms of being able to have any witnesses. That's a flawed process by any measure. I don't know of any other committee that can boast that. But the fact that we're here under an emergency meeting, that this has to be done like right this second, tomorrow, because it is absolutely so vital.
We're claiming my time on that point. We're claiming my time on that point from my friend because he raises a very interesting point. As the gentleman well knows, we could have called this meeting last week. Most bills don't sit for 6 months, as the gentleman explained on a contempt resolution from 2008. They get reported out of committee at night, and they show up here the very next morning. But in this case, the chairman of the committee said, I don't want to bring it to this. No. I don't want to bring it to this. Let's not drive this train. Let's wait.
Well, the gentleman,
let's wait.
Factual,
be happy to yield.
Yeah, one of the resolutions that we're considering, we didn't get until yesterday. Last night. So when, all this time that the gentleman is saying has elapsed, one of the resolutions we didn't get until last night. So, I mean, we are rushing this. And I don't know what the emergency is. Let's see where we can work this out, avoid this kind of terrible confrontation, because quite frankly, the process is flawed, and that's why people like myself question what the real motivations are here.
You would think you could work something like this out. I'd ask you, Mr. Cummings. I mean, here, we're talking about a memo. The chairman's reading the testimony, disclosing the memo. He's reading the notes where the attorneys won't let him discuss the memo. He's down there in a meeting with the White House yesterday where they're practically waving the memo in his face and saying, but I'm not going to give it to you unless you agree to my terms and conditions. Treating this with that kind of cavalierness, I find troubling. And I would ask you, we ought to be able to find that accommodation. I mean, have you asked the Attorney General to be compliant with this subpoena from Congress?
I have from where we are now. I mean, recently. You mean talking about recently?
Well, I guess I had in my head that if you'd asked him in the beginning, he would have done it, and because he didn't.
Yes, we have. I've also sat in the meeting where, and again, I want to emphasize is again, I wasn't in the meeting yesterday with the staff folks, whatever, but the meeting I was in, you just asked for one thing: a good faith effort to bring this contempt situation to some type of conclusion.
How do we do that when they have the documents the Congress is asking for, and they say, we'll only give them to you if? That is not how you respond to a subpoena. You respond to a subpoena with production of the documents. And I'm sympathetic to what you're saying. I'm thankful now that I received the assignment on the Rules Committee instead of the Oversight Committee as I originally requested. Because
and if you were on my side, you'd really be glad you were over here.
how do you respond to that? As you were telling the tale earlier about how many documents there were and how long it takes to compile them and who knows and when they knew and how difficult it is to put all that together, I was persuaded. When the chairman tells me that he was standing there in the presence of the memo and folks dangled it and yanked it back, I find that troubling.
Well, the chairman wasn't there. His staff was there. He wasn't there.
As he relates the story.
No, but again,
do you find that troubling, Mr.
First
Cummings?
of all, I don't think anybody was dangling anything. I think basically what they were trying to do was trying to I've been in the meeting with the Attorney General and with the chairman, and I watched him. And he basically was almost pleading to let's try to work this out. And he explained as best he could, that he was concerned about certain documents because they were a part of the deliberations within his organization. He used the words that revealing certain documents would have a chilling effect. This is the internal documents. Now, I don't know what the documents were yesterday. And he said it would stand in the way of folks being able to have dialogue amongst the members of staff. And these are, by the way, these internal deliberative documents are documents that have time and time again come under assertions of executive privilege.
These kind of documents have been found not to be covered by executive privilege.
I didn't see the documents, so he didn't see them either. So, again, I still say that if we are going to find the first cabinet member in history in contempt, we should be able, as reasonable people, to get this thing resolved. That's why I asked Mr. Boehner. I believe that if Mr. Boehner got personally and directly involved in this, I believe that we could really work this out.
Given the trust deficit of government among the American people today, I would argue there is no more important committee on Capitol Hill than yours.
And Mr. Woodall, yes, let me say something to you, sir. I agree with you. I agree with you, and that's why I have argued, many times about the integrity of this organization. That's why I have done it over and over again. That's why I've said don't go out making accusations and then looking for the facts. I believe in integrity. It is very important to me. I live by it. I practice it as a lawyer, and I believe in it. And I believe that when you put out a product, it should be a product that people can believe in. And I think that if we take this Attorney General and find him in contempt tomorrow, I'm telling you, I think that it's a stain on us as an institution, particularly when there is an effort to work things out.
We have 24 hours, and I would urge you with all my my mind. I don't think he'll take my phone call, but he'll take yours. And I would urge you to do what you can to have those documents produced by tomorrow, because I don't think there's a one of us here who's going to take pleasure in that vote.
Thank you.
I yield back, Mr. Chairman.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd like to begin my remarks by making it very clear, adopting yours, Dr. Fox's, Mrs. Slaughter's, and Jim McGovern's, and Mr. Woodall's comments and echoing them, and knowing that Mr. Cummings and Mr. Issa and their staff carry the gravity of the circumstances giving rise to Agent Terry's death. And all of us in this institution owe answers and the deepest kinds of apologies that could be offered, bipartisan or partisan, or to Brian Terry's family. It should not go unnoticed what Mr. Cummings said regarding the fact that he reached out immediately once he learned of the circumstances, a week after his nephew had been killed in a firearms situation. These are not comfortable times in our country. And this is not a comfortable exercise for our country. Being older than most of you, Mrs. Slaughter and I, and Chairman Dreyer, and you, Mr. Chairman, have participated in all of the recent situations dealing with contempt. In the matter pertaining to Attorney General Janet Reno, it has been mentioned that when a good friend of mine, Dan Burden, brought the matter out of his committee, yet another person that I know well and have great respect for, certainly his intellect and his understandings of the history of this institution. Then Speaker Gingrich saw fit not to put that matter on the floor of the House of Representatives. In the matter of Jim Watt, John Bolton, Harriet Myers, entirely different propositions. And to answer my good friend from Georgia, Mr. Woodall, who asserts correctly that we are here to protect the Constitution, the simple fact of the matter is executive privilege is also a constitutionally protected part of our enormously endowed our government's all three branches. We're on the cusp of a historic precedent coming from our United States Supreme Court, regardless of their findings, or more than likely on tomorrow. And here we are with the time period spending that I believe that we will correct about student loans in this country. Here we are today discussing contempt. Our transportation infrastructure in this country is seriously in need of repair. And here we are talking about contempt. We need jobs desperately in this country. I read a statistic yesterday that said that 56% of children that graduate, or people that graduate from law school, cannot get a job. And here we are talking about contempt. I said to the fine young staffers that worked with me when I learned that we were going to do this, that I felt it was contemptuous for us to even be considering contempt. Now, let me tell you why. Chairman Issa, do you know who approved Fast and Furious?
The approving officer was Lanny Brewer. However, there's no evidence that he personally signed the OCDEF. They're normally delegated down to a regional level.
The approving officer, what position did Lanny Brewer hold
He was the head of the criminal division, the number 3 at Justice.
at the United States Justice Department?
That's correct.
Who and
But again, that is normally delegated down as probably as low as, at the time of the OCDEF forming, Cunningham and Dennis Burke would have been people who were clearly involved, but may or may not have gone all the way up there. And this is not uncommon. This is one of the challenges in OCDEF, and it's something I know you have a history looking at these various things for many, many years here in the Congress. All kinds of agencies feed into it, ATF, Justice, DEA, ICE agents, and yet the actual accountability typically tends to be, for all practical purposes, a U.S. attorney.
how do you characterize Bill Newell?
Well, we had him before our committee. He was one of those people who testified live, and we would say that he certainly was a responsible individual involved in
Was he a
fasting.
rogue?
Yeah. No, I don't think a rogue is as accurate as this. He was, in my opinion, and I think the committee's opinion, an advocate, if you will. And this is one of the problems is the advocates for these kinds of big wins, these kinds of big programs existed and continue to exist within ATF and other agencies of the government. That's part of I think the most important part of why we take seriously the political appointees and the supervisors placed over these individuals is they're part of that check and balance.
Agreed. Mr. Issa, you and I served for a number of years on the Select Committee on Intelligence.
Yes, sir.
And I heard you a moment ago, and I'm going to come back, Mr. Cummings, and ask you to, if you would, after this question, respond to the initial question that I asked Mr. Issa and his offerings to that question with his answers. But I just want to make it very clear that I believe you know that there are many times in the executive branch when documents are redacted. And you spoke of when you saw some papers, I don't know where it was or when it was, that they were blocked out were your words here today. And I do know for a fact not anything at all about those papers. And I want to put my bona fides on the table here. I've not spoken with Mr. Cummings about this matter. I've not spoken with you about it or any member of your respective staff. I've not talked to the Attorney General of the United States about this matter, nor any of his staff, nor have I talked to the President of the United States of America or any of their staff, and I have not talked with any of the leadership of the Democratic Party to get any talking orders from anybody. Where I'm coming from is from the heart in my head and experience in this matter. And there are times, because of confidential informants, there are times because of wiretaps. And I want you to just put a tack in that word, wiretap, and I'll be right back to it after Mr. Cummings answers the question that I asked initially.
It's my understanding, and from all our research and the documents we've gotten, Mr. Hastings, that this investigation was designed and implemented by the Phoenix office. Now, you asked about Mr. Newell. It's a fact that Mr. Newell was a part of all these operations. All right? I mean, he was rogue. There's no ands, ifs, or buts about it. And that's what I got from looking at the documents.
I appreciate it. Mr. Issa, your committee and or your staff received information from whistleblowers. Am I correct?
That's correct.
Did any of those whistleblowers offer up to you information that you learned after you received it, that involved wiretap information?
Yes, sir.
Did either you or your committee pause at that time to question whether or not you should even have access without the approval of the judicial branch of wiretap information?
Well, I think, Mr. Hastings, the answer would be that my professional staff and I reviewed the question of whether or not we could open and look at these sealed documents. We believe strongly that the seal is there to protect, as it should be, by a federal judge, to protect against a disclosure that could compromise the ongoing investigation. Wiretaps have a life of their own, and when they're over, they're over. We could have moved to have them unsealed, and then we could have made them more wide.
Sealed?
They were sealed. They are sealed. We did
By
by a federal judge.
district court judge?
That's correct, and as they had been for a long
And you
period of time.
didn't feel uncomfortable going forward and saying, hold on, let's go to Your Honor or His Honor and ask for permission to go forward with that information?
As you know, these wiretaps documents can be viewed by hundreds of people throughout justice. The question is, on a sealed document, is my understanding, and unlike you, I'm not a trained lawyer.
I have managed a substantial number of wiretaps.
Right. Those wiretaps, it is about whether or not they get disclosed to individuals that would be detrimental to the reason they were sealed. Congress has a right and a need to know, so after evaluation, we made a determination to read them, to understand them. We already had been told by an ATF agent a summary of what he believed they said as far as the wire gun walking. We have maintained them closely held, and this is something I think the ranking member and I are very proud of. There are only 2 copies. Ranking member has a copy, I have a copy. They're kept in safes. We've maintained the spirit and the fact of these sealed documents. We have not published them. We will not publish them, and they are for eyes only of members of Congress. We think that's appropriate based on separation of power.
Therein lies a part of the problem, Mr. Issa, and that is one thing that you and I and everybody that works inside the Beltway knows is that eventually matters that are purportedly secret will reach the public realm. But beyond that, when the whistleblowers, in my view, provided you with wiretap applications, I believe that the Department of Justice may have been prohibited by law from producing them. Thus, some of the documents that you are speaking to, I would ask Mr. Cummings whether or not you feel that some of those documents are prohibited or to be allowed to either your committee or in any way into the public realm.
I was very concerned. Still am very concerned about it. As a matter of fact, Mr. Hastings, when we were sent these documents, first of all, we made sure that they were limited to just 1 or 2 people on my staff because I just felt so uncomfortable with them. And one of the suggestions that I made in letter form to the chairman is that we go to the judge and find out from the judge.
You have a letter to that effect to Chairman Issa?
Yes, I do. And because I thought as an officer of the court, sealed document, criminal penalty of 5 years. I had a lot of concerns.
Yeah, well, you all are walking on very thin ice when you receive information from anybody that is under the aegis of a Title III wiretap. And I would urge the staff of your respective committees, ranking and majority, to review that information very, very carefully. Mr. Issa, I want to return to the 2-day interview. Who was interviewed?
If you're talking about the 4th and 5th of July.
3rd and
Or-
4th of July.
Third and fourth? Make sure I've got my right. Okay, Kenneth Melson.
Kenneth Melson was interviewed. All right. And during that period of time, I asked you previously, and I ask you again, on the day that you say he voluntarily came in, was he placed under oath?
I believe the answer is no. No, he wasn't sworn.
And then how was Mr. Cummings or his staff notified that there would be a second day of interviews?
The gentleman behind me informed his staff after he came in and gave us voluntary statements. And Mr. Hastings, I want to make it very clear. This is a gentleman who you can't have it both ways, and it's not part of today's contempt, but I'll be full about it. You can't say, well, he said under penalty of criminal charges that he didn't know anything about it until he read the wiretaps, and then say, but we have to have him before we can consider contempt as to the withholding of documents from February 4th on. The two really are very different. We believe that his failure to do his job is part of the problem of acting people in that ATF position, which, by the way, on a bipartisan basis, Congress has failed to make sure that we have confirmed directors. And it's a problem. And I think that's one of the points of our committee, when this is all over and we get done with the dust up here, getting ATF integrated in a way in which all of us can trust them as a law enforcement agency with confirmed and consistent leadership the way the FBI and others have, is in fact one of the areas that our committee doesn't have a disagreement on.
So, you know, you and I stood up, a whole other committee, to oversee the stovepiping that was going on in the various intelligence committees. I wish you luck with the ATF code.
I know. We didn't do that well on the other one, but hopefully we can learn from it.
Mike Rogers and I had settled concerns at the time and still do. But going back to this gentleman, Mr. Melson, didn't he tell you that he didn't tell anyone at the Justice Department about the gun walking, and he's the guy you just referred to that said that he was sick to his stomach when he learned about it? Am I correct in that regard? And that would have been on the second day when he was under oath, or did he tell you that both days?
I think he told both days. And again, this was staff-led, so I wasn't personally present.
Therein lies yet another part of the problem. I sat the other night and I looked at the young staffers that are behind you all, just like the ones that are behind us. And I turned.
And you wonder how they got so good so young.
I turned and I said to my chief of staff, I was in Florida, that the people, and they are great minds, and I don't disparage them, I don't know them, but they're too young for the criticality of what's going on in this particular aspect. Too young in the sense that you now prefer, through your committee, by your 23-17 vote, to bring an absolutely historic matter to the House of Representatives regarding a cabinet official. No cabinet official in the history of this country has ever been held in contempt of Congress. I did not say, nor would I, that there were not many of them who withheld information rather repeatedly in all administrations, probably for all time. But we're getting ready to stain this institution with this particular kind of undertaking. And I for one,
Mr. Hastings, I may say the stain will be on the Attorney General's office for refusing to deliver documents that he knows he could deliver, that he has offered to deliver, but only in return for, if you will, a plea
who was at the
bargain.
White House meeting last night or yesterday? Here again, staff people.
I apologize, but that's all they wanted. That was the request.
Was the Speaker's office represented
Yes.
there?
Two of his
Your
most
office
senior people.
represented there?
Two of my two most senior
Can
people.
you stand here and honestly, or sit here and honestly say to me that you feel that yours and Mr. Cummings' efforts to get to the bottom of the information that you are seeking has been done on a bipartisan basis?
No, I cannot. I believe Mr. Cummings has not lived up to his promise. I wish he had to the Terry family. I believe in spirit he thinks he has, but in reality, the truth, the full truth, is too painful for, in fact, him to take on his own Attorney General. And I think that's one of the problems that goes on in every administration.
Well, I'll
You know,
tell you
Ms.
this,
Slaughter, before she left,
You don't know the Elijah Cummings that I know. Elijah Cummings is not a lackey or a minion of Eric Holder, nor am I, or any of us. Just like you, we have responsibilities. But when you and I worked on the Intelligence Committee, we had ideological differences, but we worked on the same matters. And it isn't only the Terry family, it is this entire nation needs to understand the dynamics of what transpired here. We know for a fact that it was a failure, and we know for a fact that Agent Terry was killed, and you have identified some people, some of whom didn't appear before your committee here today, that easily should have been inquired of long before you began investigating the investigators. You have your prerogatives. I think they're mistaken, and I think they're going to disserve this institution. I yield back my time.
okay.
I was not going to ask any questions, but, and Mr. Hastings brought this up, who gave you the wiretap affidavits? Who turned those over to the?
I'm afraid I can't answer that.
Okay.
And I hope that all the members would understand that whistleblower secrecy, particularly when they are outside of a specific ability to protect, is critical. Agent Dotson, one of our whistleblowers, has been the subject of repeated abuse by this administration or people in the administration. And in fact, there's a current investigation of former U.S. Attorney Burke for possibly leaking information as part of retaliation. So protecting our whistleblowers is critical. Those documents and all the documents we receive, we do maintain secrecy as to the source.
And I've had an opportunity to go down to the committee chambers and read those documents. You know, having served in law enforcement for 38 years and working with the federal government on numerous cases, OCDF cases also, I'm surprised at what I read. I'm surprised that those cases moved forward or as long as they did and continue to do that up until the point where Agent Terry was tragically killed, murdered, along with, like you said, almost 300 Mexican citizens.
Perhaps countless numbers we won't know.
You know, every time in law enforcement, I was chief law enforcement officer for a county. Mr. Holder is chief law enforcement officer for the United States of America. But every time I was presented with a subpoena, unless I went to court to try to quash the subpoena, I had to comply. And I understand the limitations. I understand blacking out specific things in regards to operations, in regards to investigative procedures or techniques. But at the end of the day, I don't understand, I really don't understand why the Attorney General, who I believe probably didn't know anything about this, why he would be so reticent in regards to releasing information that would clearly show that he didn't know. Particularly with all the information that was going on at the time and all the hoopla that was going on at the time in regards to guns leaving America and being utilized in Mexico to keep the drug cartel moving. It's hard for me to understand how it never reached past just Phoenix. Having dealt with the federal government on a number of cases, on drug cases, working with DEA, FBI, ICE, and others, wiretap cases, I'm surprised in reading the affidavits that it didn't move further, at least how it didn't move further. And I guess the biggest question is, obviously, the letter that received on February 4th that claimed there was no gun walking going on, and correct me if I'm wrong, it was 10 months before Justice corrected that assumption.
That's correct.
Do we ever get a reason why it took 10 months before they ever made the confession that, hey, guess what, that memo is incorrect?
That's essentially the reason we're here with contempt, is that those documents we request, a substantial portion of them would be exactly right on that question of between February 4th and December, who knew, what were they talking about, and why, when people we believe were saying this is factually incorrect, this is untrue, why that never bubbled back up to us. We do have at least one piece of information that shows as early as August, they were in a position in which they apparently knew that this was false, straight false, and it wasn't until a few weeks before December that they began working on the operatives for how they walked back from this. We have indications that they were considering walking back only from a portion of it, rather than, and I think it's Stephen Weiss, if I remember, who said, no, we got to do it all. We got to do the right thing. And, you know, there are people that did the right thing in this process, but may have been delayed by 5 or 6 months from the time they knew. And there are people who obviously knew the right thing and were officers of the court and did not come forward. It is part of our investigation, but you hit on something that I think is equally important. You've looked at a lot of wiretaps over the years. We believe, as part of where we have to get at the end of this investigation, we believe that the fundamental rules for actual accountability of reading and understanding, not a summary page, but a wiretap, of coordinating OCDETF so that you understand what some parts of it know and some don't, so that one person becomes accountable for the overall operation, that's lacking, at least in ATF and apparently in all of justice. And that's the reason that even after we do what's right for accountability for the Terry family, we're going to have to present a series of reforms, hopefully ones that will be instituted primarily by the justice itself, to make sure this doesn't happen again. And I know we've taken a long time, but 6 years ago, I did an investigation when I was a minority or majority subcommittee chairman of an organization you might have heard of, Mineral Management Service. And what we discovered was they robo-signed everything they did practically, so there'd be initials or signatures repeatedly, but they admitted to us in the investigation that basically they only saw the cover page and signed it. And so you had this look of accountability on oil leases that cost us tens of billions of dollars. You had this whole process of whether you had oversight in the Gulf over the quality of drilling rigs and so on. In 2006, we got a long way down there when we published a good report that said there was problems at Mineral Management. But we didn't take it to the next step. People died. Billions of dollars were lost. America was embarrassed. The oil industry was embarrassed. And lives were destroyed forever. Because in 2006, we knew there was a serious problem at Mineral Management, and we never did enough to try to fix them. Maybe BP wouldn't have happened if we'd seen it to its conclusion. In this case, these are human lives too, and we've got to take it to a conclusion that protects America in a way that I don't believe they're currently protected.
In reading the wiretap applications, I guess I'm confused. I don't understand how whoever read them wouldn't have been concerned with the fact that we're letting thousands of guns walk without any idea where they're going. Well, they had an idea where they're going because some were recovered in Mexico, some were recovered within the United States. But did you ever get an answer as to how that continued on for that period of time, particularly with, it's not like 7 guns walked, 10 guns walked, and we're trying to figure out who the bad guys are, because obviously in wiretap affidavit, they laid out specifically who they thought were involved, and were able to back it up through the wiretaps.
And it wasn't 7 guns or 6 guns or 10 guns. It wound up being, in some cases, hundreds of guns in a very short period of time. Did we ever get an answer as to how that continued?
No, sir.
U.S. Attorney's Office is responsible for that,
Yes, sir.
correct? Did we ever get an answer from the U.S. Attorney's Office as to where the ball dropped?
The people most closely associated with it have denied that the ball dropped. The people further away from it have said they didn't know, and that's part of the connect the two that we're trying to get to.
And so I go back to, my initial statement is, I can't imagine as the chief law enforcement officer under subpoena wanting to negotiate with you in regards to a specific area that you're concerned about as to what happened after the 4th, actually, when you got the letter, to the time they walked that back. Why would they stonewall you on that particular issue if they're clean hands?
I don't know.
Mr. Cummings?
I was sitting here thinking about, I'm going to answer your question. You're going to have to answer it again. But let me say something, because I need to get this off my mind. In my 61 years of life, no one has ever questioned my integrity. And you just did. And if we were in another setting, I would say you should take your words down. I'm not trying to protect anybody, and I resent what you said. I do, deeply.
You said what I said?
No, I'm talking about what he said a minute ago in answer to.
I answered a question.
Well,
as best
and
I
I'm
could.
telling you, you questioned my integrity, and I resent what you said. Now, what was your question?
Well, I can see you were upset and you were stewing over there.
No, I'm not stewing. It's just that.
Well, I mean, here's my question. You were an attorney. I was
Yes, I
not.
am.
I was a cop. But when presented with a subpoena, have you ever been presented with a subpoena?
Yes.
Did you?
But I'm not the Attorney General of the United States, and I'm not the person who asserts certain privileges, as Mr. Hastings was talking about.
Does being the Attorney General of the United States preempt him from a lawful request from Congress, a subpoena, to produce documents? Does he have the ability just to say, I'm not going to do it? Or I'm only going to do it to such a point as I want to, and after that?
Well, it's not as simple as you're making it sound. When you're asking me for wiretaps, if you're asking me, as Attorney General, for wiretaps, for things that are going to interfere with a investigation, for, let me finish, confidential informants, so it all depends. Or if you're asking me for things that might be subject to executive privilege, that's a whole other thing. So, and I think that's been part of what we've been going through.
Well,
that's a good answer, but I'll give you the other side of that answer.
okay, I'd love to hear it.
All we're asking for is every single responsive document that, in fact, would not compromise an ongoing investigation and would not be part of a court seal or some other prohibition. We can have a discussion with those separately. What the Attorney General has clearly said in testimony and through his employees and himself in that meeting last Tuesday is, no, I'm not going to give you any part of my deliberative process unless it serves my purpose of bringing this to a conclusion. Then I will give you a selected group after you agree to that. Ultimately, it is that only that small part. We're not talking about wiretaps. We're not talking about things which a court would object to or that would compromise ongoing prosecutions. We're talking about things which we believe he has every right to give us, but he is saying that when it's deliberative, He will choose what we get or don't get. Meantime, that deliberation was about false statement made to Congress and the period of time in which they debated various aspects of it being untrue and what they were going to do about it. Now, Mr. McGovern objected to the reference to Nixon, but that's the definition of a cover-up. Something is said wrong to send people in the wrong way, and then there's a period of time in which you try to support a wrong statement. All we're asking for, and the reason for contempt is, we were told a lie. We want to know about the deliberation for 10 months between the lie and the truth, and that's the information we seek, and that's the information the Attorney General has said, no, I won't give you because it's deliberative and it doesn't serve my purposes.
One of the things that the Attorney General did say also was that he was protecting institutional concerns. You remember that?
Sure. His
And,
institution has the right to lie and then talk about it, is what he's saying.
You see, this is what I
Well, let me ask you, do you know what the institutional concerns are that he's trying to protect?
he didn't go into that. He did not go into that.
But you know all we're asking for. The contempt is fairly straightforward here on the rule. It is in fact about documents during this period of time that would be responsive to the false statement made in February 4th of 11 until the time it was retracted. And I will say for all of us, and I know that Mr. Hastings and I had great service together behind closed doors, and we fought together against then the Bush administration when they didn't want to cooperate, and that was hand in hand up and down the dais. If we cannot have access to the information related that is necessary for us to do our discovery because it's deliberative, then in fact we have a closed government system in which we simply give them the money and go away. If we in fact cannot have, when we've been lied to, discovery about it, then where do we go to get the truth?
I thank both of you for your comments. Thank you.
Thank you.
Let me just say that we have 13 votes on the House floor, and I very much hope that we'll have a chance to hear from Mr. Terry's representative, the Dean of the House, Mr. Dingell. And so, Mr. Polis.
Thank the chair. First question is for Mr. Cummings, and then I'll go to Mr. Ice on it. But on page 12, the contempt citation states, the subpoena was issued following 6 months of constant refusals by the Justice Department to cooperate with the committee's investigation into Operation Fast and Furious. And first I'll ask Mr. Cummings, you know, again, the record shows that prior to the date of the subpoena that had that quote that I just mentioned, the department had produced over 2,000 pages of documents for the committee, made an additional 1,195 pages of documents available for in-camera review, briefed the committee 4 times, and made 17 witnesses available for transcribed interviews. In your view, does that constitute, quote unquote, a constant refusal by the Justice Department to cooperate with the committee's investigation?
I think the Justice Department has cooperated quite a bit with us. And again, as I said earlier, I think there were times when there were issues over certain types of documents that were subject to, you know, like that he could not produce because they were, like, say, wiretap applications, things of that nature. But I think they've worked pretty hard. Keep in mind, they had to go through millions of emails and thousands upon thousands of documents, and they actually had to go to 240 custodians to get the documents, and they made 42 presentations to our committee of documents. So that's quite a bit of work in a little bit of time.
Thank you. I asked the chairman if there might be a way that I can see the witnesses. Can the camera possibly be moved?
I would ask.
Okay. Thank you. Okay, that's better. There you are.
Very powerful.
I asked the same question to Mr. Issa with the following, lead-in. Again, the words matter. You know, exact words matter. We're in the business of words. We're passing words. This is a specific contempt citation. It says constant refusals to cooperate, constant refusals by the Justice Department to cooperate. It seems to me what you're talking about here may be appropriately conveyed as a partial refusal. It may be an incomplete compliance, but I find it difficult to see how the words constant refusal are consistent with the cooperation that occurred, albeit in your eyes insufficient.
No, I
the
agree. I
cooperation
agree with you
occurred.
that that's a point that needs to be clarified. Constant in some areas, cooperative in others. And as we narrowed from 22 areas, of which at least 10 were never complied with at all, down to this one, we narrowed from 10 places in which there was zero compliance to one. The fact is there were 10 places in which there was zero compliance. So you're absolutely right that you could say, well, they gave us all or partial cooperation in, let's just say, a dozen areas, while giving little or nothing in the rest. Is that partial compliance? And I think you could have a semantics argument. In this case, the contempt is about one area in which there has been zero cooperation and zero production.
The contempt citation also states very specifically on page 39, quote, to this moment, the President himself has not indicated he is exerting executive privilege, end quote. I would ask, again, we'll start with Mr. Cummings and then go to Mr. Issa, isn't, in fact, the President's assertion exactly the way that previous presidents have always asserted this privilege? Is that correct?
That's correct.
And I ask Mr. Issa, again,
I'll clarify it.
History.
You're reading a pre-amendment. We amended that at the markup.
Okay.
So it actually doesn't say that.
Okay. Do you have
You just have an earlier version for some reason. My staff informs me.
There you go. Well, again,
But understand that the part of the problem is we received, at the moment the markup was to begin, the executive privilege letter, if you will, as part of a letter from the Attorney General.
Yeah.
And that was untimely, to say the least. But rather than allow it to be like a death row inmate not wanting to have 11 years later an execution, we worked during the markup in order to amend appropriately what you now see.
So just my final set of questions here for Mr.
Let me
Issa.
just say this.
Yes, Mr.
My
Cummings.
staff tells me that they rushed so quickly trying to make the amendments that they the information is still in the document.
Yeah, and that's the version that I had to study last night. It's possible it has changed.
Unless it's changed overnight.
Probably and going to the floor. It's, again, this is all happening very quickly, and that's a whole other matter why we're not having a proper vetting discussion. My final set of questions. First to Ms. Issa, do you have any evidence that the President of the United States knew about or authorized gun walking?
We have only two pieces of information. One, the assertion of executive privilege in a way in which we cannot be sure whether the President is asserting his own knowledge or the deliberative process that up until now we believe is the Attorney General's assertion. And that's unclear, so we'll just leave that one alone. The second one is we do have evidence of emails that went from Phoenix to a member of the President's national security team, and that has been a situation in which the administration has been unwilling to make that individual who is the recipients of the emails or the emails in their entirety available to us.
Yeah,
but to answer your question as I did on Sunday Talk, which is where that question came from, the answer is I have no specific knowledge, nor are we looking to the President. We are looking to the truth on behalf of the Terry family, and that's why we want the documents that we've asked for.
And I asked the same question with regards to the Attorney General. Do you have any specific evidence that the Attorney General knew of or authorized?
During the inception and the participation through the death of Brian Terry, we have no evidence, nor do we currently have strong suspicions. We, just the opposite, have a number of people, including Lanny Brewer, who should have known, whose responsibility was to know, that is part of our ongoing figure out who's responsible and where the wheels fell off of the appropriate cart.
But Mr. Polis, we are now, I hope you listen to what he just said, but we are now about to fine in contempt the Attorney General of the United States of America after you just heard that.
Sure, for what he said he wouldn't do.
Well, hopefully we are not about to. I certainly prevail upon the wisdom of my colleagues, to consider this motion and come down the right way and on the vote on the floor.
It's not for what it's not for what the attorney knew about Fast and Furious. It's for the Attorney General's refusal to provide the documents lawfully requested under.
Well, again, I
That's
mean-
what contempt is.
Well, there we go. They were going back again to that initial language. I think even you are not asserting a complete refusal. You're citing incomplete cooperation.
As to the period February 4th
Well-
to December, there is a complete refusal, and now, on top of that, an executive privilege claim. As to the narrow subject of the contempt, which is limited to that, yes, there is a complete
I mean,
refusal.
what of the one moment? But what of the 2,000 pages? What of the 1,100 pages that were reviewable? What of the 17 witnesses? I mean, I don't see how that can even be
I don't-
reconcilable with the term refusal.
Substantially, none of them, if not absolutely none of them, cover the period February 4th to December about the false documents given to us.
Let me go to Mr. Cummings on that before I go to Mr. Hastings.
I'm sorry, what was your question?
Oh, I was asking about again, have you found there to be at least some degree of cooperation? Again, reasonable debate whether there's been enough. Is there some degree of cooperation?
Yes, there had been some degree of cooperation.
Okay. Ergo, not a refusal. Refusal is a complete lack of.
There is a refusal as to the area for which we seek contempt. You know, you can answer everybody's questions but one area and then tell the judge, I'm just not going to give you that. That is contempt. And that is why you have a very simple question before you. All the extraneous information that we've helped educate you with here today has absolutely nothing to do with the narrow question of, from the time we were lied to for those 10 months, those documents.
Yield to gentleman.
Is there an Inspector General's investigation ongoing, and when, if at any point, if you know, the report is
Mr. Hastings,
issued?
they're on their second Attorney General in over a year. So, quite frankly,
Inspector General,
Inspectors General,
right.
they're on their second Inspectors General. They had 10 months, I believe, of the predecessor and now 2 months of the new one. And to be honest, we don't know when or if it will happen. What we do know is, in fact, that the Inspectors General was given 80,000 pages, and we've been given 10% of that. The Inspectors General may not ask some of the same questions. Certainly, the February 4th to December apparently is not part. In other words, the false statement to Congress is not part of that investigation, as far as I know.
And so how do you sum up the Attorney General's responsibilities to the IG versus your committee?
Yeah, well, he seemed to be more responsive to the IG by far than to us.
Would you not allow that is a part of his responsibility in light of the fact that he's the one that stopped Fast and Furious and ordered an Inspector General?
Brian Terry's murder in a canyon in Arizona stopped Fast and Furious, from what I can tell. And the Attorney General referred to the IG more than a month after, I believe, approximately a month after Mr. Grassley, Senator Grassley, sent a letter. So the Inspector General's request appears to be prompted by Senator Grassley. The concern by the Attorney General appears to be as a result of the inquiry after Brian Terry was killed. That seems to be the indication, but I can't be sure.
Okay. I thank you. I'll yield back the balance of my time.
Thank you, Mr. Chairman. I have a question of Chairman Issa. I want to make sure that I understand this. I have a document here that says that there were 140,000 pages of information.
Is your mic on?
Relative, it says approximately 140,000, relative to this Fast and Furious. Is that true?
Yes, that's what the Attorney General had said in
You've
previous
gotten
testimony.
7,600 pages.
That's correct.
There was an offer, it sounded like, as late as yesterday for another 1,300 pages.
No, the
Okay,
1,300
sorry.
was a hypothetical. The offer apparently is less than 300.
Okay, so I'll stick with the 7,600. If I owed you $140,000, would you accept for full payment $7,600?
If I thought it was your last 7,600, yes. Otherwise, I'd like to get a fairer share.
I don't blame you.
And we've always been willing to compromise and to do in-camera review to limit the discovery and the burden of it. We want to get to the truth, but we know that there's much of the truth contained in those 140,000 we've been denied.
Well, if it reversed, I wouldn't be as merciful as you're being. I will say this, though. Let me just ask this final question. If if 132,400 pages were accessible to you before the vote on any of these issues, would that suffice what you're asking for? Would that be the solution that Mr. Woodall said? Where do we go next? Would that suffice what you're asking
If
for?
those documents were made available to the committee, it would cause a postponement, and if those documents were as they asserted to be, it would end this standoff altogether, I have no doubt.
Thank you.
Gentlemen, thank you very much for being here. We appreciate your
Can I
testimony.
stay to
Now
hear
we're
the
very
dean?
happy to recognize the distinguished Dean of the House, our good friend from Michigan, Mr. Dingell, who I know is Mr. Terry's family's representative. Please, Mr. Dingell, without objection, any prepared statement that you might have will appear in the record in its entirety, and we welcome your summary.
Thank you, Mr. Chairman. I appreciate your courtesy. Thank you, members of the committee. For the record, my name is John Dingell. I'm a member of Congress from the 15th Congressional District. I did not roll off the cabbage wagon yesterday, as you all well know. I've run a number of investigations, did it for probably about 28 years, and I've always gotten the papers I set out to get. I am very strongly of the belief that this matter should be returned by a motion which would require the matter to be referred again to the committee on from which the matter originates. Agent Brian Terry is a citizen of Flat Rock, Michigan. His family are constituents of mine, and I think getting the facts is extremely important. I have had a number of occasions to cross swords with BATF. I am a strong defender of the Second Amendment and have consistently opposed restrictive firearms legislations, including the activities of the Bureau of Alcohol, Firearms, Tobacco, and Explosive, which I find to be a rogue agency very much out of control. I would note that we have heard in this little or nothing about the committee's interviews or discussions with or appearances of BATF personnel before that committee. And although their appearance has been requested on repeated occasions by the minority members of the committee, that kind of assistance from the full committee and from the chairman has not been forthcoming. I believe what we need here is a strong and a vigorous and meaningful investigation of the matters about which the chairman and the majority members make complaint. And it's my view that with proper effort, that could be achieved, and I would very much like to see it because I have, on a number of different occasions, had to go into serious misbehavior by BATF, including on an occasion where they shot an innocent citizen out in the Washington suburb, or rather the Maryland suburbs of Washington, shot the husband in the head with an enhanced performance 9mm bullet and pitched his wife out into the hall in runner pants. And then they went outside and put their BATF armbands on. They were dressed as hippies and walked back in to conduct the what they continued to put before the public as a training exercise. And I repeat, they were bearded and unwashed and looked like hippies. I would note here we are observing a situation where BATF has given a dignified, I think, retirement to all those who were involved in this unfortunate matter. And I see no signs that any action is going to be taken. I would like to see that matter investigated. I believe that if the Attorney General needs to be called upon to produce documents or papers, that he will certainly do so. And I note that there have been offers by the Department of Justice and the Attorney General to produce documents at the behest of the committee, but with only a request by the Attorney General that there be certain constraints with regard to public discussions of these matters. I was informed of this morning with a discussion with the Attorney General, and I've seen that in the reports of the minority members who have sought to have ATF brought before the committee. I note again that the ATF has not been brought here before. I would note that in my time as chair and subcommittee chair, I've gotten large numbers of documents. I've had to duel and to deal with recalcitrant White Houses of both parties, Democrats and Republicans, and I've always gotten the documents, and usually on terms which were acceptable to all. But I would note that not infrequently these were surrounded by reasonable conditions which showed the necessary and proper respect for the executive branch of the government and for the president, something which I believe is correct. I would note that during my years as committee and subcommittee chairman, a number of persons were found to be in serious wrongdoing, a number of whom were prosecuted successfully, and a large number of taxpayers' dollars were returned to the public, in spite of the fact that we did have claims of executive privilege from Republican and Democratic White Houses. Having said these things, I would urge the committee, Mr. Chairman, to make rule in order and to make motions to refer these resolutions to the committee from which the request for contempt comes, and along with motions to table and motions to postpone to a date certain, these motions would be available to all members if the resolutions were considered to be in regular order. Mr. Chairman, the business of investigation is an important and necessary power of the Congress. It goes back to the late 1600s when a British parliamentary committee caused a collapse of the government because the English Parliament found that the government had sold out the Dutch allies of Britain. And the result was that that was really sort of the beginning of parliamentary oversight of the executive branch. It's a very important power. I do not appear here to see to it that we do not investigate, but rather that we do so vigorously and that we commence with the agency which has the knowledge of the events, i.e. BATF, an agency which has, as I have indicated, engaged in a number of serious incidents of wrongdoing, attacking the rights of citizens, their persons, their homes, and their behavior, without any proper justification in many of these instances.
Well, Mr. Dingell, let me thank you very, very much for your thoughtful testimony. And your recommendation to this committee is that we make an order a motion to refer.
Yes, sir.
I understand that, and I think that your perspective on the issue of oversight. Now, you didn't participate in any of those hearings in 1600, did you? I know you weren't a member of the British House of Commons.
Later.
Okay, I just wanted to make sure, because I know you have vast experience. I didn't know exactly how far back it reached. So let me thank you. It's very clear what your request of this committee is. Are there any questions of Mr. Dingell on his request for a motion to refer? Thank you very much. Thank you very much for being here, Mr. Dingell. That will conclude the hearing portion, and we are going to stand in recess. As I said, we have a series of 13 votes on the floor right now. And what we intend to do is reconvene at the beginning of the last of those 13 votes so that we'll be able to report out. So the committee stands in recess. Thank you very much.
And I thank you, Mr. Chairman, for your courtesy. Have a good day.
We did it to your colleague. Colleague argued.
The Rules Committee will reconvene. We are here this afternoon to mark the birthday of Jennifer DeCasper. And so we'd like to, we've convened this meeting. We delayed because we wanted to make sure that both you and Mr. Scott were here, Jennifer. So happy birthday, many happy returns. And now to the dull part as the celebration comes to an end, and we'll entertain a motion from the gentleman from Dallas.
Mr. Chairman, I move the committee report a rule providing that if House Report 112546 is called up by the direction of the Committee on Oversight and Government Reform, all points of order against the report shall be waived and shall be considered as read. Rule provides for consideration of the resolution accompanying House Report 112-546 under a closed rule. Rule provides 50 minutes of debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform or their respective designee. The rule waives all points of order against consideration of the resolution accompanying the report. The rule provides that the resolution accompanying the report shall be considered as read. The rule provides one motion to refer at the conclusion of the debate if offered by Mr. Dingell of Michigan, which shall be debatable for 2 minutes equally divided and controlled by the proponent and opponent. The rule provides one motion to recommit with the resolution accompanying the report with or without instruction. The rule provides that the chair may reduce the minimum time for electronic voting on the motion to recommit the resolution accompanying the report as though pursuant to Clause 9 of Rule 20. The rule also provides for consideration of House Resolution 706 authorizing the Committee on Oversight and Government Reform to initiate or intervene in judicial proceedings to enforce certain subpoenas under a closed rule. The rule provides 20 minutes of debate on House Resolution 706 equally divided and controlled by the majority leader and the minority leader or their respective designees. The rule waives all points of order against consideration of resolution. The rule provides that the resolution shall be considered as read. Finally, the rule provides one motion to recommit House Resolution 706.
Oh, okay. Let me just thank the gentleman for his motion and say very briefly that this resolution allows us to move ahead and deal with these two proposals before us. As we said, we provide an opportunity for Mr. Dingell's motion to refer. We have, if you look at the issue of contempt as it was dealt with in the last time, we did not have the kind of opportunity for members to be accountable as will be the case in this instance. And so I know that there are more than a few people who are not pleased that we're proceeding with this, but I think that in light of the fact that we are doing this, we are doing it in a way that does allow for an opportunity for members to have go on the record on the issue. We know very well that the priority of having a highway bill, which will include the extension of the student loan issue, needs to get done. And I should say, as we proceed, that we're planning to meet at 2 o'clock tomorrow on the financial services and defense appropriations bills, and we hope that we also will be able to have a conference report that we'll be able to report out, because I know Mr. McGovern has raised that issue repeatedly. So are there any amendments to the rule?
I just have a comment, Mr. Chairman.
Yeah, Mr. McGovern.
Yeah, no, I just would point out that this is the first time in the history of our country that we're going to hold a cabinet member, in this case the Attorney General of the United States, in contempt. Given the fact that that was pretty clear during the testimony today that the process in the Committee of Jurisdiction was anything but bipartisan, not a single Democratic witness was allowed to testify. The idea that we're going to take this matter of significant gravity up and debate 50 minutes, 20 minutes, and 10 minutes just seems to me to be the wrong way to go. I mean, I think a lot of members would want to participate in this debate. I know under regular order, I guess we get a total of 60 minutes, but, this is, and I appreciate the time constraints, but this is a big deal. Yep. I'm tired of having big deals being given a little bit of time because we have to take another vacation. So I just
Thank
point
you.
that out.
No, I appreciate that. Let me just say we'll have 2 hours and 20 minutes if you look at the amount of time that this will be considered. Vote occurs in the motion of the gentleman from Dallas. Oh, Ms. Lutter. Sure. Oh, I'm sorry. I thought you. I would have recognized you certainly before I recognized Mr. McGovern. My gosh, with the effort that you make to come in here, I mean, I just assumed that when if I go to Mr. McGovern, that, I mean, you
That
know,
I'll be quiet?
well, I mean, just a dream, you know, that,
No.
it's aspirational on my
Let me
part.
just say, we're really pleased that Mr. Dingles.
Good.
Will
You can say that
have his
anytime you
time.
want.
Appreciate that. But there is one thing that you've got, if this is brought up,
Mm-hmm.
and that kind of intrigued me there for a minute, because I remember that Speaker Gingrich had the wisdom once not to bring one to the floor. Can we hope that that might happen here?
I think we're proceeding. I think that's the
We're gonna
plan
go
as of
ahead.
right
I
now.
see.
So we'll have a vote on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no. Madam Chair, the ayes have it. The ayes have it. The motion is agreed to.
Roll call, please.
Clerk, call the roll.
Aye.
No.
No.
Mr. Chairman, if we do this, history will judge us harshly, if any of us care. No.
Aye. And Mr. Clerk, the total? And the motion is agreed to, and Mr. Nugent will be managing this measure for the majority, and Mr. McGovern for the minority. And as I said, we'll look forward to a meeting at 2 o'clock tomorrow. Without objection, the committee stands adjourned.